Okay, it appears that we have a quorum and we'll begin the Closing the Justice Gap Working Group meeting. This meeting is being recorded. And with permission of the chair, I will start with the roll call.
Please do.
Okay, Justice Duker.
I'm here.
Mary Baldwin. Becky Sandifer. Marta Alkenbrock.
Present.
Judge Irma Asbury.
Here.
Judge Wendy Chang. David Engstrom.
Here.
Bridget Grammy.
Here.
Tom Green.
Here.
Eric Helland.
Here.
Dan Grunfeld.
Yeah.
Kathy Huang. Micah Star Liberty.
Here.
Hold on. Can the record reflect that Kathy Huang is here? I think she was on mute for a moment.
Okay. John Lund. Kevin Moore.
Here.
Wendy Musell.
Here.
Kristen Passmore.
Here.
Toby Rothschild.
Here.
Jim Sandman.
Here.
Patricia Scutiero. Sacha Steinberger.
Here.
And Andrew Arruda, who will be late, I believe. Okay.
No,
I
think he just
Andrew's
arrived.
with us. Yep, there's Andrew.
Oh, Andrew is here. Okay.
Okay.
I
So
thought it was-
before we move on to the next item, I just want to say that John Lund is on vacation and he sends his regrets, is really sorry he can't be here, but he's somewhere on a beautiful river, so we can't be too sorry. And the other two co-chairs, I was actually speaking to them moments ago, so I'm sure they'll be with us shortly. Which brings us to the next item, public comment. Are there people present at today's virtual meeting who would like to provide public comment?
If there's anybody who would like to provide public comment, please use the raise hand function to indicate that you'd like to do so. You'll be given 2 minutes. Okay, we will start with Leonard Sansowitz. Give me 1 second. Okay, Leonard.
Can you hear me?
Yes.
We can.
Okay, thank you. That's my dog, by the way, not me. Thank you for hearing my comment today. I'm a Los Angeles-based plaintiff side employment attorney. Many of my clients are and have been low-wage earners. I've represented many undocumented clients as well as clients who speak little to no English. I have several concerns with the materials that were released for today's meeting. First, I encourage the working group to adopt a resolution that the regulatory authority or Sandbox entity operate as a private nonprofit organization, not as an arm of the state. Second, the Sandbox entity should under no circumstances accept donations of any kind from private funding. Similarly, it should not be funded by private money such as venture capital, even for startup funds. Rather, it should be funded from applicant fees and from a public fund supported by grants or taxpayer money monitored by state oversight. Third, I'm very troubled by the idea that the working group is considering a workaround to the Constitutional and Business and Professions Code requirement that all persons who practice law in California must be active licensees of the state bar. No person shall practice law in California unless this person is an active licensee of the state bar should mean what it says. Fourth, I'm extremely troubled by the idea that the group is considering as a possibility attorneys who have had their licenses suspended or revoked could have any percentage of ownership of paraprofessional entities or any participation in their decision-making processes. The state bar disbars attorneys because it deems them to be a threat to the public. Allowing them a side door to re-enter the practice of law seems inconsistent with that concept of public protection. Fifth, I continue to be shocked that the working group is now entertaining a proposed mission statement that provides that public interest is served by providing competent and affordable legal services to underserved or unserved individuals and small businesses in California. Small businesses or corporate interests generally were never considered in the Closing the Justice Gap 2019 report, and the inclusion of such language in the mission statement of the scope, thank you, would confirm the fears that many of us hold that the Sandbox is not set up for the purpose of helping the most needy, but rather for providing an opportunity for businesses to exploit the most underserved in a pursuit of profits over people. Thank you for my time.
Thank you, sir.
Okay, 1 second. Okay, next we have Daniel. Sorry, I can't pronounce your last name. Gyces? Daniel, you have 2 minutes.
Can we have the spelling of Daniel's last name?
It's Ghyczy.
Okay, thank you. Go ahead, sir.
Yes, hello. My name is Daniel Gitsy. I am a third-year attorney on the plaintiff side for personal injury in Los Angeles. I know there's been a lot of talk back and forth about various measures, but I think that something hasn't been addressed yet, as far as I know, is that people, attorneys in my position who have taken out loans, gone to law school, really struggled financially so that we can provide to our communities. You know, we aren't the people taking the obnoxious fee rates. We're not the people taking advantage of advertising and second opinions. And we are out there putting in the groundwork. We never turn a client away. We have the resources available. And we have a community even of new attorneys through CALA that allows us to communicate which clients are in need, which clients can't afford to pay some of the bigger law firms, you know, their contingency fees. And there's always a market and there's always someone available. And I worry because I have friends and colleagues and support staff in my office that see what's happening and they worry, is law school worth it? Why should I go through the hassle of taking out these student loans if it turns out I can't compete with people once I make it out of law school? I think it's very troubling that I pay my dues. I pay my dues. You know, I'm lucky. I've only paid them for 3 years so far, but I feel like as though the best interests of the community and the people that are really in need of legal help are being satisfied right now. And it feels as though the measures that are being proposed are not being proposed to help anyone other than the people that are, first of all, proposing them. And second of all, the people that stand to profit even more so than they are now, without having to go to law school, without having to meet their ethical obligations like I do every day in my practice. Thank you.
Thank you, sir.
Okay, next we have Oliver Taliu. Oliver, you have 2 minutes.
Good morning. Can you hear me?
Yes.
Hi, good morning. My name is Olivia Talia. I'm a partner at BD&J, a personal injury practice. I started my career out of Melvin and Myers practice in that field for quite a few years before switching to personal injury. My main concern, and the one that I want to relate to today, is that the scope of the proposal, as demonstrated by the proposed application, which was taken from, I believe, Arizona or Utah, includes substantially practice areas which are not underserved by the current legal community. For example, and I'll use the field that I practice in now, which is personal injury. We represent clients who have less than nothing. The personal injury model, which bases its fees on contingency, is designed to help people who do not have resources get help for their injuries. And therefore, that is a community that is not underserved under any stretch of the imagination. The proposal also includes categories such as employment, workers' compensation, so forth and so on, which are also very well served in the legal community. What this proposal is going to do is it's going to allow the access of venture capital funding into the practice of law, which will allow major corporations like Google, Facebook, Amazon to be able to take advantage of the monopoly power in advertising and price out everybody else in the industry, which ultimately will result in consolidation of services, not competition. If one has any doubt, just try to take an Uber between downtown and Los Angeles airport. A ride which normally costs $40 to $50 is now costing $120 to $160. That is because the lack of competition in the transportation industry has allowed these companies to now exploit the consumers and charge outrageous rates for services which used to cost a fraction. That's exactly what's going to happen in the field of law. Once large corporations are able to monopolize the area, they will price out everybody else in the market, and
You have 10 seconds.
consumers will be left with less choices and paying more for the services that they're now receiving. Third of all, I'm concerned about the state bar's ability to regulate these corporations. The state bar was not even able to regulate Tom Girardi, who's had many, many complaints with the state bar. And as we can see by recent news events, state bar has been utterly unable to regulate the people that it already is supposed to regulate.
Olivia, your time is up.
Thank you, sir.
Okay, next we have Abraham Neiman.
Yes, hi, good morning, and thank you. I'm a pretty recent admitted to the California Bar, plaintiff side, personal injury and employment. I just wanted to add my voice to all the concerns that have been said already, that, you know, this proposal is just going to hurt the community of attorneys, price us out, and reward those who do not need to go through law school, do not need to take out all the loans, and do not need to conform to the ethical requirements of the law. That's it. Thank you.
Thank you.
Okay, next we have Cameron Perkins. You'll have 2 minutes.
Hi, can you hear me?
Yes.
Hello. I'm not a lawyer in any sense. I'm actually a student at a community college, and I'm planning on studying communications. Am I allowed to ask questions here, or just comments? I see there's a question and answer box down below. Would that be more beneficial to type in a question there?
Actually, this is for public comment, not for dialogue. So you're welcome to share any comments you'd like to share.
Got it. Thank you. I'll type in the question down below.
Okay,
Thank
thank you.
Okay, next we have Jennifer Ostertag.
Good morning. Thank you for your time. I'm an attorney for over 20 years in Los Angeles, representing employees and injured parties. I have extreme concerns about the state bar ideas of allowing non-lawyers corporation to own law firms for profit. I think it's a bad idea. It would not help to close the justice gap or provide access to justice. We have already seen what it has done in the medical field. When private equity firms were allowed in the medical profession and placed profit above access to healthcare. I mean, one of the perfect examples, which is being looked at by Congress, is Prospect Medical, which mostly served low-income patients. It's Leonard Green extracted over 400 million in dividends and fees for itself and investors in its fund, while the medical facilities were left with broken elevators, dirty surgical gears, bed bugs, water leaks, no fuel for ambulances, etc. Prospect has even closed the hospital that he had promised to preserve, to the detriment of the low-income patient that they were supposed to provide healthcare to. And it's exactly what's going to be happening in the legal field if we allow corporation to own law firms for profit. So I strongly urge you to reconsider your position and to think about the people who need access to justice, who are being provided, and who need our protection. Thank you.
Thank you, Ms. Ostertag.
Okay, next we have Jeannie Harrison. You'll be given 2 minutes. Jeannie, are you with us?
Sounds like you better move on to a next presenter.
Okay, 1 second. Next we have Annette Morash.
Hi, for the past 13 years, I've been a housing rights attorney. I have my own law firm, law office of Annette Morash. 99.9% of my clients are extremely low income or homeless. I work on contingency. This idea by the bar, which I pay to protect me and to protect my practice, will ruin me. It will ruin my practice, and it will hurt the people that I attempt to help in this city. If this passes, I'm going to send the State Bar of California an invoice to repay me my $130,000 in student loans plus 10% interest since 2005. A lot of people are very nice and measured in their comments, but this idea is absolutely stupid. Thank you.
Thank you. Were there other requests to give public comment, Mimi?
Yes, we have Jeannie Harrison with us now.
Okay.
Jeannie?
Can you hear me?
Yes,
Yes.
we can hear you.
Oh, great, great. Okay, wonderful. Thank you. I'm Jeannie Harrison. I represent women who've been sexually harassed, sexually battered, and others who are discriminated against at work. My clients include the no profile to the high profile, nannies, nurses, bus drivers, the victims of Harvey Weinstein, and the women of Riot Games and their equal pay class action. I fight against abuses of power that target and victimize people, and I'm also the president of Consumer Attorneys Association of Los Angeles. This committee's express mission is to enable corporations to provide legal services, but corporations' sole fiduciary duty is to maximize shareholder profits. And to do so, they market in ways that are appealing to achieve their goal. It is a fiction that corporations are altruistic. Texaco and Chevron claim to be environmentally responsible. Big Tobacco told us that cigarettes don't harm people. Purdue Pharma and Johnson & Johnson told us that OxyContin is not addictive. Consumer attorneys fight corporations in court, holding them accountable for what they actually do, which is put profits over people. And for those of you who have the best of intentions on this committee, please be clear about what's going on here. In Utah and Arizona, hedge funds and investors are not calling consumer lawyers to start businesses for the underserved or underrepresented. They're calling to get in on mass torts and catastrophic injury cases. And we know because those plaintiffs' attorneys who receive the calls have told us about the calls. The State Bar wants to allow corporations to own both sides of the V. And this committee's purpose is to facilitate that. Once corporations are allowed to practice law, they will directly target the cases of the consumers they harm through other corporate practices. You will not prevent Johnson & Johnson from owning a law business to capture the cases of its opioid victims. It is truly remarkable that neither the State Bar nor the California Supreme Court have required from members of this committee conflict of interest disclosures or commitments not to participate in any way ever in any business that would benefit from this committee's work. It's also remarkable that the committee talks about what data of victims of abuse who are looking for legal services should be sold to allow them to be targeted by corporate data mining.
You have 10 seconds.
There is false comfort in the rules of professional conduct or regulations. Local prosecutors have testified to the PPWG that they do not have the capacity to police the new paraprofessional licensees, much less the corporations that are salivating over this new profit-making
Your
market.
time is up.
Thank you.
Thank you, Ms. Harrison. Are there other public comments, Mimi?
Nope, I believe that's it.
Okay, thank you to everybody who provided public comment. We will move now to the announcements section of our meeting, and I have the privilege of announcing that we have 3 new members of our committee, and I'm going to ask them to introduce themselves one at a time, but I will tell you that our new members are the Honorable Irma Poole Asbury, Superior Court Judge in Riverside, California. Wendy, I'm going to need help pronouncing your last name.
Musel, thank you.
Wendy Musel from Oakland, California, and Sasha Steinberger, also from Oakland, California. So their names are on the roster that was distributed to committee staff. And I'm going to ask you in the order I just read your names to just say a little bit about yourselves. What is it that draws you to, besides the fact that we asked you or that someone asked you to serve, what is it that drew you to make an application and be excited about serving on this committee? Judge Asbury, you're on mute, but if you could unmute and share with us, we would love to hear. We'd love to get to meet
all
you.
the time. Good morning, everyone. I'm glad to be part of this committee. I'm very interested in this topic. I was a practitioner for 28 years before I went on the bench. And I largely did work as a practitioner in family law, and I understand the need to have good quality legal representation for those that can't always afford it. I fortunately had an assignment in family law for 6 years, and after that I did 4 years in criminal, and now I'm in my 5th year in civil, and I continue to see that need. I'm very interested in this topic. I am grateful to hear the public comments that we've had this morning. There's a lot to consider, but I think there is a lot that we need to do as well to make sure that we're doing things that allow all persons access to the court. And so I'm here and ready to work. Thank you.
Thank you, Judge Asbury. Wendy.
Good morning. I'm honored to be here. I'm the State Assembly Judiciary Committee designee, which I'm extremely honored to fulfill that role. I'm a partner at law offices of Wendy Mussel. I'm also of counsel to Levy, Vinnick, Burrell and Hyams. Since 1999, I have represented employees solely related to whistleblower discrimination, harassment, wage theft cases, predominantly on a contingency fee basis, which is how most of the plaintiff's employment bar serves clients, which means that we don't get paid until there's some sort of resolution on behalf of our clients. I particularly represent individuals who work for public entities, both state, federal, local governments. That's one of my specialty areas, as well as whistleblowing. So I'm thrilled to be here. I think there's a lot of very interesting issues that will impact the law for many years to come. So I'm excited to have a voice and to hear the rest of you and your perspectives.
Thank you and welcome. And Sasha.
Hi, everyone. I'm glad to be here as well. My name is Sasha Steinberger, and I'm a former plaintiff side employment and civil rights attorney. And then I started Legal Link and run it still. We're a Bay Area nonprofit, and at Legal Link, we're attorneys, but we train and support and focus on non-lawyer community partners. We train them to act as community-based navigators with the low-income populations they serve. So these partners are mostly staff at nonprofit organizations, and they work to house and employ and stabilize low-income families. So our goal through this work is really to expand the legal ecosystem in order to remove barriers to poverty alleviation. So poverty alleviation is our main goal. All of our work is squarely within the realm of what non-lawyers can already do. But in that work, I look forward to sharing what we've learned about how people experience the law, where the holes are, and what more community partners could do with some shifts.
Thank you very much. Welcome to all three of our new members. We also have a new face on the screen on the staff side. Since our last meeting, Leah Wilson has been appointed, or should I say reappointed, to lead the State Bar, and we're thrilled to have her with us today. Leah, do you want to say a few words?
Sure, thank you. I'm really happy to be able to join the meeting today, although I apologize in advance, I will be in and out. I very much enjoyed and learned a great deal from the initial foray into this world with the ADLS task force. And I'm really looking forward to getting up to speed on where all of you are. I've had a few orientation sessions with the staff team and tried to read up on things. And I'm just really excited about your work. Appreciative of your taking the time for this very challenging endeavor, and look forward to where we land. So thank you.
Thank you. And we're lucky that with your appointment, Donna Hershkovitz gets to surrender a few of the duties she was so ably carrying on a temporary basis. But Donna, will you bring us up to speed on further changes expected at the bar?
Yes, absolutely. Thank you, Justice Chuker. I am really excited to announce, and this is going to sound funny when you hear the first part of the sentence. I'm really excited to announce that Bridget Graham is going to be stepping down from this working group. And that is simply because Bridget is actually going to be joining the State Bar staff as the Deputy Chief of Programs. And so she will be attending this working group in the future in that role, in that staff role, working very closely with Randy and Andrew and Leah and myself on this group. So I just wanted to welcome Bridget to that new role, and just very excited with all the experience that she brings to the role of Deputy Chief of Programs, and the ease with which she will step into the staff role in supporting the team of this working group. So thank you.
Thank you, Donna, and congratulations, Bridget, on a
Thank you.
new job. You're starting when?
The 23rd, so a couple more weeks.
Okay, so you're here today as a member of the working group, but when we reconvene, you will not be.
Right.
Okay, so that's excellent. Thank you. That brings us, we've sort of naturally merged into staff reports, but Randy, would you like to present the rest of the staff report for us, please?
Thank you, Justice Tucker. The only staff item I want to mention is that Angela did circulate the 2022 schedule of meetings for this working group. If you have any sort of completely immovable conflict, please let us know. We do want to make sure we have a quorum for those dates that we have selected. They were difficult to select because we do have to work around the schedules of all the leaders, as well as work around the Board of Trustees meetings, because next year we will be fitting in the actual public comment periods, which we need to request by going to the board. The other aspect that's not reflected in what was circulated is that we will continue to, of course, have our subcommittee meetings. And now that the full working group schedule for 2022 has been distributed, we will be now working with the subcommittee chairs to program into that schedule the subcommittee meetings. So if you're one of our subcommittee co-chairs, please look for that. But that's all we have from staff.
That's super. Thank you very much for moving that item forward so that we can all put these meetings on our 2022 calendar and protect that time. We're gonna have a lot of work to do next year. And we're gonna get a lot of work done today, but before we move to new business, is there a motion for approval of the open session action summary from our last meeting held on June 18th, 2021?
So moved.
Thank you, Kevin.
Thank you, Kevin. Do we have a second for Kevin's motion?
Second.
Thank you, Toby.
Rothschild. Okay, I will take the roll call vote. Marta Alkenbrock,
Yes.
Andrew Arruda,
Yes.
Judge Irma Asbury.
I think I need to abstain.
I believe you abstain. Mary Baldwin. Judge Wendy Chang. David Engstrom.
Yes.
Bridget Grammy.
Yes.
Tom Green.
Yes.
Dan Grunfeld.
Yes.
Eric Helland.
Yes.
Kathy Huang. Micah Star Liberty.
Yes.
John Lund. Kevin Moore.
Yes.
Wendy Mussel.
Abstain.
Crispin Passmore.
Yes.
Toby Rothschild.
Yes.
Becky Sandifer.
Yes.
Jim Sandman.
Yes.
Patricia Scutiero. And Satya Steinberger.
Abstain.
Thank you.
Okay, thank you all. Mary, you're going to be chairing the discussion on our next item of business. So why don't I turn over to you to lead our conversation on the structure and governance recommendation that your committee is bringing forward for the consideration of the committee on the whole.
Okay, thank you, Justice Tucker. Hi, everybody, and especially welcome to the new members. Hopefully one or more of you will be drafted to our committee. I'll leave it to you to fight it out as to who wants that plum assignment. So we've been looking at the issues of how the sandbox regulator should be structured. And we've started looking from the beginning, looking at all these various options. We had a memo with legal research done by the State Bar staff, which is in your materials. And I will get to that in a minute. And what we have here today, after many discussions, both in this working group and also at the SAGE committee level, discussions about specific ideas around the structure, we've decided to try to coalesce these ideas and actually put forward a set of proposed resolutions to try to shape the structure and governance of mostly the structure right now of the Sandbox regulator, to try to move forward, because we're very conscious of the timetable that we're working under. And we could certainly spend a lot more time talking about all of these things, but we think that we feel pretty resolved about where we've gotten to in these discussions, and feel good about putting forward this set of draft resolutions. So what I'd like to do today is go ahead, talk through the proposed resolutions. I'd like input from the members of the SAGE committee who helped draft and prepare these. That would be Bridget, Eric, Jim Sandman. I think you had some input into this set. I know you had primarily into the other, and then Daniel. I don't know if Daniel's here. And so I'd like to discuss, I'd like to get the committee's views, and if possible, even pass some of these resolutions. But before we get there, I do want to say that we did have this legal memo that Brady Dewar's team at the State Bar put together with input from us on leadership level, and also from the committee. So, we previewed this memo at the last working group meeting, but then since then you've received the final draft. So I did want to open it up for anybody to ask any questions of Brady. He's not going to do a specific presentation on the legal research. He did that last meeting, but I do want to let anyone ask questions of Brady about the contents of that final draft memo. So I'll just open it up if anybody has any questions. Brady knows he's on the hot seat, so he's ready. He's ready to go. Okay, no questions. I like that. Brady likes that.
I'll just jump in and say thank you, Brady, for the research that you and your team provided. I think it was very helpful to the SAGE committee in coming up with the recommendations. And it could be that even though no one offers questions now, there will be opportunities for you to comment based on the information that you came up with as the discussion proceeds.
Sure.
But thanks, Mary. It sounds like you can carry on.
Thank you.
Okay, great. Thanks, Brady. And really thanks to your team. Okay, so let's move then into the discussion of the proposed resolutions. And again, these are put forward as a way to generate input and discussion. It's not like we're suggesting that we simply pass these as a rubber stamp. That's not at all what we're doing. But what we wanted to do was really try to take a big step forward with the issues that we've been discussing for some time. So these are numbered, and we could, we can approach this any way we want. I will just start, with number 1, which is the Sandbox regulator will be established by the legislature as a public corporation within the judicial branch of government, serving as an arm of the California Supreme Court. So this comes, directly out of the research that Brady's team did, and also, of course, much discussion that we had considering the various possible alternative kinds of structure for the Sandbox regulator. I don't know, would Bridget or Daniel like to say anything about, or Brady like to say anything about this first resolution?
This is Dan. This is consistent with the analysis that the committee, Bridget and I, presented 2 meetings ago, and the various choices and options that we ultimately looked at and followed through on based on that discussion.
So with that, is there any other, so moving beyond the kind of drafters, Brady?
I was just going to make the observation that this structure basically recognizes some of the limits that antitrust law imposes and the non-delegation doctrine in terms of how the judiciary can delegate its power, and recognizes the oversight that's needed by the judiciary, and the fact that, as we investigated the sort of private nonprofit option, there were, it would be harder to address the antitrust and delegation issues. There were some additional issues in terms of, it wouldn't have liability from litigation the government entity would. So seeing very few benefits there and some risks there, this was consistent with the legal analysis also.
Okay, so then opening it up to members of the committee. Does anybody have any thoughts to offer on this first resolution? You will recall that we considered, various options, including a nonprofit, including other. We had, I think 3 or 4 different scenarios, and this was the one, as Brady said, that we felt was most consistent with the existing regulatory structure that would allow us to do something. So let's see, Kevin, you're on mute.
I just have one question. Is there going to be any cross-fertilization with the state bar to coordinating efforts to regulate the delivery of legal services? Or will this governmental organization, this public corporation, pretty much be on its own? For an example, say, would there be cross-fertilization of the boards of the 2 entities? Is that something that you've considered?
So I'll just answer that with respect to this first, item of the resolution doesn't purport to have a broader reach than just what it says. So the issue of how the regulator might work with the state bar is open and would not be determined by how we vote on this first issue. If you notice, proposed resolution number 5 here does talk about the board and how the board would be appointed. We haven't given, and if you look at that resolution, it doesn't address what you've termed as cross-fertilization with the state bar. And I don't know that that's necessary for us to reach that. I mean, those are important issues, and those are things that we could, that we or the regulator could work out as we go forward. But I don't think it's this resolution doesn't intend to address or limit that issue. David? Oh, sorry, Kevin, did you want to?
No, thank you.
David? So I think I might benefit from hearing from, you, Mary, or others, how this deviates from, some of the other versions of this that are out there in the world. So Utah, for instance, or maybe even the UK, it might be interesting to hear. I mean, those are the other data points. And so just as we try to zero in on the structure, and I'm sorry if this has us retread debate we've already had, but it might be worthwhile to understand how this structure is different from some of the things that are already in existence. It might help us to spot problems or issues. That's a good question. We were focused in our analysis, just as a little bit of background, more on what were the possibilities within California law and California regulatory structure, more than we were focused on looking specifically to Utah and the UK around how they do it, because we were really focused, and Brady's memo makes this clear, we were very focused on, what California law allows us to do or doesn't allow us to do. I don't have a particular, specific information on either how Utah is structured, nor it's certainly not the UK. If others here in the conversation want to provide that information, welcome. But that was not how we approached this. So unfortunately, I can't give you a good, clear answer on that.
I can jump in with a piece of an answer, which is that my understanding is that Utah does something very similar, but slightly less formal, in the sense that they do cite their Sandbox regulator under the supervision of the Supreme Court, which is very much what we were seeking to do. But the specific language here about it being a public corporation and serving as an arm of the Supreme Court is actually a parallel to the state bar. So it's the same language that's used to define what the state bar is. So this is an entity that is independent of, but similar to the state bar in how it is situated within California state government. And I think we put the brackets around public corporation partly because that's not maybe a frequently used term, but I don't know that we need those brackets at this point because basically it's a corporation organized to be part of public government in the public interest, the way the state bar has been organized, constitutionally speaking. We're just not a constitutional entity the way the state bar is. And by that, I mean called for and designated in the Constitution.
Wendy?
I think Allison may have answered a little bit of this, but my concern was, would this structure allow for the regulatory compliance and particularly enforcement if it were organized in this particular way? Meaning, would there be any limitation that would limit the ability to address if there's abuses or violations that individuals or corporations needed to be removed from the sandbox?
Great question.
That's a good question. And Brady, I think maybe if you wanted to speak to this, my understanding was that this structure would not limit the regulator's ability to enforce sandbox rules and regulations. And we haven't yet devised our specific kind of regulatory and compliance scheme, but my understanding was that this structure would allow for that. It's obviously an important part of any regulator. But Brady, did something that you looked at?
Certainly, this structure wouldn't limit the ability for enforcement at all. This regulator with the structure could build up a staff as it's currently contemplated in number 3. The sandbox regulator would actually make ultimate recommendations to the Supreme Court as far as mission, discipline, then those would have the effect of a court order. Because of potential conflict issues for the court might delegate that to other judicial officers, special master, but ultimately it would be the court making the orders. They would have the effect of law, just recommendations regarding attorney admission.
Bridget, did you have your hand up?
I'm having trouble with the mute button. I think you mostly answered that. I just wanted to assure Wendy, because I know that you're just joining all of this discussion, is that the idea behind this is really to be a parallel entity to the bar, but with the same regulatory authority. And so for sure, the consumer protection element is a really important part of that. And the enforcement part of it it's probably going to look different than the way it does at the bar, but it certainly is a huge part of what we're envisioning for the regulator.
Micah?
Does the Government Tort Claim Act apply to this public corporation?
It would.
It would. And what kind of immunities do you anticipate this particular corporation would benefit from?
Without any change in law, I can speak as somebody who's written demurs to claims at the state bar. What comes up is there's a specific immunity for granting or denying or revoking a license. There's an immunity for exercises of discretion. Those are the big ones that come up. I believe some might be listed in the memo, but again, the typical immunities afforded to government officials and government agencies.
Okay, and I know that it says, and I don't know if this is a question for you or someone else, but I know that it says that the hope is to have applicant fees cover the expenses. And then there's a sentence that says, ideally, the startup funding would be funded by the general fund as a pilot program with the possibility of appropriate grants. Has anyone done any sort of analysis as to what the ask would be of the legislature in terms of a contribution from the general fund?
Micah, can I just say that's not, we haven't gotten to that yet. We're really just focused on number one here. That's it. Well, we need to have a comprehensive discussion about funding, but if you could just hold that question for when we get down there, that would be great.
Absolutely.
All right, thanks.
Thanks.
Any other discussion about number one? Wendy? You might be on mute.
Yeah, my apologies if this was answered in a prior session, but is there a reason why this just can't be part of the state bar in its current, iteration as opposed to creating a new entity?
Well, anyone can join in, but I can tell you that some of the discussion that we had was that first, putting this regulator within the state bar conveys a particular, it certainly conveys the sense that this is for lawyers and about lawyers and governed by lawyers, as opposed to something different, which could be a disincentive for others to get involved in the sandbox. I think there were also concerns about, wanting to create independence from the state bar, not burden the state bar. I think those were some of the concerns that were raised, that we thought it was preferable to set this up separately so that, with a different board, a different set of staff, although possibly having some support functions being provided by the bar under contract. That was one of the things we looked at. We did, among the options that we looked at from the beginning was housing this regulator within the state bar, but we decided fairly early on that that was not the preferred alternative. I don't know if anybody else wants to weigh in on how we reached this decision and why this one is preferred. Please, welcome.
That was a good summary, Mary. I don't really have anything to add there.
Any other questions or input on number one? So we can, I'm happy to proceed however we want to go. If we want to, someone wants to make a motion to approve number one, or if we want to talk through the remaining proposed resolutions and then do it as a group, either way is fine with me.
Mary, why don't we continue through with our discussion on a one-by-one basis, and then at the end, you can figure out, or anybody who wants to make a motion can figure out which ones we're prepared to make a motion to approve at this time, either individually together.
Yeah, that makes a lot of sense. All right, so now let's talk about number two, and this addresses funding. And if you recall, from ADLS, one of the tasks that we were given was to, address how the sandbox would be funded. This is a preliminary stab at that. We have not, obviously gotten to the point where we have any idea about budget or, what this is likely to cost, but this is more conceptual and kind of structural around how the sandbox would ideally be funded. And this specific proposal envisions that the sandbox regulator will eventually be funded primarily by applicant fees. But we recognize that startup funding is going to be necessary in order to set it up properly, including providing important functionings like monitoring, data collection, and consumer protection, which, I think we discussed, of course, is a cornerstone. Those issues are primary to ensuring that the Sandbox does what we hope it would do, while at the same time, as a fundamental and cornerstone piece protecting consumers. So we envision that this would be funded by the general fund as a pilot program. Possibility of appropriate grants. You'll recall that we talked at length about whether private grants could be in terms of the legal structure, whether it could receive private grants. This resolution doesn't purport to say that it should receive those grants, but just that there's the possibility of those grants. It's too early to say whether there's even, I think, any grants that would be possible. And then this last sentence, and Bridget and Eric, I think we'll want you to talk about this. We envision that the legislature might continue to appropriate funds to subsidize applicants who are working specifically to provide legal services to those who cannot currently afford them. Bridget and Eric, a question came up. This is language that you added, and would love to hear you talk about it. A question came up, which is this envisioning funds to subsidize applicant fees only, or is this intended to address something beyond, subsidizing applicant fees?
I can answer that. We hadn't really talked in detail about that, Eric. I don't know if you had a different vision of it, but I think the concept by this whole resolution number 2 is what we are trying to accomplish here is to we're trying to identify some stable sources of funding, basically, is what we're saying. And in order to be an adequate consumer protection regulatory agency, we have to make sure that the funding is in place. We don't want to rely only on philanthropy for this. I mean, if that happens, that's great. But our hope is that we could put some kind of proposal together for the legislature that they might consider funding with general fund money. And, part of that could be specifically earmarked, I guess, to address applicants that are proposing products that would directly impact the justice gap. And so to the extent that could be applicant fees or whatever that might look like, we hadn't really gone into detail yet, but just to kind of start building into the infrastructure of what we're proposing, ways to ensure or incentivize people to develop particular products that would address the underserved. Do you want to add anything, Eric?
Assuming I can figure out how to unmute myself. No, just 100% to what you said. I think we had envisioned this as, since we aren't sure what the costs that would need to be covered by the applicant fees, the question is, could they, would it be discouraging applications if we tried to cross-subsidize for, say, nonprofits or others who might want to undertake something that maybe was not a profit-making entity. And so we were kind of envisioning sources of funding for that would both fund the Sandbox, but also not discourage those kind of applicants. And we had a number of discussions in our subcommittee that, one of the things you would really like to do is target those underserved areas, but they're sort of almost by definition the places that you would not be making a profit such that you would be willing to invest heavily in fees. So this was sort of an attempt to kind of capture that language from our subcommittee discussions.
So I just want to make sure I understand. So this sentence is addressed to subsidizing application fees for those kinds of entities, or is it does this envision some kind of broader financial support?
No, I think I don't, Bridget, we didn't actually discuss this, but I think we really had just intended this to just be the fees.
Okay.
To answer the question that David Engstrom's going to ask in a minute, Utah does do this differently, which is that it is funded by private philanthropy, as I understand it, and there's not fees associated. So they didn't really have this issue. So in our discussions, we were trying to think of a way in which we could approximate what Utah was doing for making it very easy to apply while not necessarily relying on private philanthropy, which for a state as large as California, that might be a very big ask from a philanthropic funder. I guess while I have the mic, I'd also make one point in the comments, someone commented on startup funding for this entity. We had intended that to be starting up the entity, not startup funding as in tech startups or something like that. So the idea here is none of this would be private corporate money. This would be grants or something like that, or funded by the legislature.
Thanks for that clarification. I would note that yes, we used the word startup. That does have a couple of specific meanings, but I think this third sentence in the resolution does make clear that we're using that as meaning the initial funding to start up the regulator. And because we specifically say there that it would be funded by the general fund. So we're not intending to reflect sort of venture capital or some kind of private funding there. So thanks for that clarification. Kevin?
Yeah, I was a little taken aback by this sentence, or I should say not taken aback, it was more confused, because our mission statement is talking about attracting entrants who are going to serve the unserved and underserved folks who are out there. And yet this seems to contemplate, implied in this sentence, is that we're going to open it up much wider. The sandbox will be opened up much wider. So I'm wondering if we're putting the cart before the horse. I know that's a horrible analogy to use on this when we're talking about technology, delivery of legal services and the like. But why are we saying that we're going to subsidize perhaps applications when shouldn't all the applications be aimed toward serving the underserved, at least given the current status of our discussions regarding our mission statement? Could somebody address that for me, please?
I guess I would invite Bridget or Eric to comment, but I think that we understand that, especially within the scope subcommittee and then within the working group, we are, this is an issue that we have spent a lot of time discussing. I don't think it's resolved yet. And my understanding that this would be here as, to the extent that we end up with a sandbox that might offer, might be open more widely than only to organizations that serve low-income people, then this just is a sort of aspirational provision suggesting it to try to keep the focus on and make it possible for applicants who do serve that population. Again, this I don't think is intended to weigh in on that specific debate, which, as you know, as a member of Scope, is something that we are actively working on through your committee's efforts. So that's I guess what I would say about that.
Okay, and just as a follow-up, I very much appreciate how you've tried to break up these resolutions into bite-sized pieces, recognizing the difficulty that had to have been involved because there's so much interrelationship between these various proposals. And one thing I'm thinking of when you say that the funding of the office is going to be through application fees, then I'm wondering how large those application fees are going to be. Granted, California is larger than Utah, but at present they only have at most a few dozen approved applications. They have a very small office. And I'm thinking, especially given the earlier statement regarding enforcement capabilities of this new entity, is that the staffing would have to be much larger than what appears to be the handful of paid staff in Utah. So it's just something to keep in mind that all of these things are interrelated. But again, I very much appreciate how you have broken these down into understandable resolutions. I'm not asking a question. I'm just making that point.
Thanks, Kevin. Tom?
Yeah, I wanted to just chat briefly about the preceding sentence, this possibility of appropriate grants portion. So it strikes me that this is something we need to be very careful with, and sort of 2 points that I'd like to throw in the mix. One is we should require, if this happens, I think we need to get disclosure of the financial interests of the people that are giving grants. I mean, some, surface nonprofits are subsidized. They get their money from people that would have financial interests, so need some disclosures here. The other aspect, which may be equally important, at page 20 of the staff memo, there's this whole discussion about potential recusals. And I don't think we should put ourselves in a situation where we get any money that would force the Supreme Court to recuse itself. So maybe put a parenthetical in there or something, but I just think we need to recognize that this is potentially a fraud form of financing if we go in that direction.
Was that fraught or fraud?
Fraud. F-R-A-U.
Okay. I just want to make sure, because I'm reading the transcription too, and if we're going to be throwing around words like fraud, I just wanted to make sure that I understood it's fraught. Okay. And yes, understood. And that was the issue of Supreme Court recusal, if you recall, was something that we have spent some time talking about, and our representatives from the Supreme Court have weighed in on that. And that's absolutely right, which I think is intended, all of these considerations, Tom, are intended, I think, to be addressed by the use of the word appropriate grants. And again, this resolution is not intended to set criteria for how grants might be assessed and weighed and what grants might be appropriate or not, but because all those considerations and probably more would go into deciding, how to accept funding from outside for this kind of venture. It's absolutely right.
I understand appropriate could cover a lot, but I think surfacing either as a footnote or adding a parenthetical or something, I think it might be helpful if we at least recognize that there are some crucial barriers we want to maneuver around.
If I can jump in with a process point here, when we write a report, it will definitely need to have more details. And I think that just by flagging the issue, you are giving important input to the SAGE committee.
Okay.
But I want to reinforce what Mary said, that this is not meant to be the last word. If we disagree with the statements that are here, I think we need to say, no, we disagree with this. But if we say, yeah, that's all well and good, but we need to say what appropriate means, I don't think that needs to be done necessarily right now. So I appreciate your point, Tom, that before any report is written, we're going to have to address things like disclosure and what kinds of grants might be inappropriate. But for purposes of, and therefore for purposes of this discussion, the comments are excellent and right on point. But in terms of what do we need to do before we have a resolution we can vote on today, I would encourage you to remember that all we're doing right now is a first step in the step-by-step process of giving guidance to the SAGE committee. Yep, we agree with this much of what you've said so far, or we don't. So now keep going down that path you are treading.
Sasha?
Yeah, just going back to the issue of nonprofits and the application fee and how those that subsidy would work. I'm curious if there has been philanthropic interest or if it's appropriate to include that here, that it says ideally it would come from the general fund, but there's no mention of philanthropy. And I guess I'm curious why that was left out or if there's room to include it. Yeah.
So yeah, good question. The appropriate grants is where we intended to include within that. I mean, the grants would be, as we contemplated it, would include philanthropic grants like Utah, which is how it is primarily funded. If anyone thinks we need to make that more clear, given that this, that is part of the same sentence where we talk about the general funds, maybe we do need to make it more clear. And again, this is not to say that we are, suggesting a specific means of funding, but just to envision possible sources of funding is what this was intended to do. So if anyone wants to suggest a revision to that, please do. I would just say that, appropriate grants, and as Tom has already fleshed out, and thanks Justice Tucker for reminding us that this would be part of, our overall report, in which time we would give more discussion of appropriate grants. And Sasha, to your point, we would explain that some of those grants might come from philanthropic sources, subject to the kinds of considerations that Tom raises. Wendy?
Thank you. Just 2 points. Following up on what Thomas and Kevin were raising, I have a concern about philanthropic monies being funding an entity that will be regulating the people who are putting in the money. Meaning if you have a small business or particularly corporate interest that is participating in the Sandbox, if they're also either directly or through entities that they own or substantially affiliated with, if they are providing those philanthropic monies, that could cause a conflict or an appearance of bias. And so that's something I think we should be thinking about. Additionally, I wondered about the likelihood of the legislature for their appetite of funding, particularly a separate entity, separate from the state bar, since the state bar is already funded and exists for regulatory compliance.
So just on your first point, absolutely, conflict of interest and bias issues are foremost. And, we are, again, we're trying to take small steps here and biting off specific pieces. There will be a comprehensive conflict of interest policy that, we develop as we roll forward in this process. And again, and that's something that is of concern to the Supreme Court. And it's something we've spent a lot of time talking about, with the Supreme Court representatives on the committee, and it's addressed in the memo that Brady drafted. So the appropriateness of any philanthropic, support that is received, that is part of the analysis that would determine the appropriateness of that funding, because it's essential that this be done in such a way as to especially not create conflicts, for the regulator, for the Supreme Court. I mean, the program has to be run in that way. The second question you raised about the state bar, so going back to, I guess, number one, funding. In terms of the legislative appetite, I don't think we're in a position right now to know what that is. I don't think that we have good reasons for proposing the structure that we have. This is not the end. Again, these resolutions are really intended to help guide SAGE as we roll forward. It's not the final word on any piece of this. So, but I don't, again, I don't know what the legislative appetite is. Maybe someone else wants to address
Mary,
that.
Can I jump
Please.
in on this to make one point? Obviously, we want to be careful with the state's money and what we would ask of the legislature. So one of the ideas that we had was to have an independent regulator, because it's a different kind of regulation for different entities, and needs at some level to be separately accounted for, because the bar is funded, as I understand it, with attorneys' fees. And obviously attorneys for the most part wouldn't be involved in Sandbox entities, or to the extent they are, they would then be paying fees to subsidize the work of the separate regulator who separately regulates those separate activities. So in some sense, it's to be, fair to lawyers not to ask them to pay for the regulation of these entities, of these different entities. But to be wise with the legislature's money, we would definitely be interested in and understand there would be no legal impediment to, and I think a lot of practical wisdom to doing the following. Although the entity would be separate, it could contract with the state bar to receive services. And Mary made a brief mention of this earlier, so I'm just elaborating on the point. To, for example, get IT services and HR services and maybe general counsel services from the same folks who are doing that sort of work at the state bar. But there'd be a line item that says the state bar staff is being paid by the state bar to do that work, except to the extent they're contracting out their services to this other entity. So we don't want to recreate and superfluous services and bureaucracies where we can use the same resources by contracting, but it makes it possible to have the flow of the license fees and the control of the entities represent the fact that we're talking about two different kinds of licensure, individual lawyers for the state bar and entities that are Sandbox participants, you know, for the Sandbox for the new entity. Does that make sense?
I understand. Thanks for giving me that information.
Okay. I'm somewhat hampered. I can't tell who raised their hand first. And let me also just apologize. I'm using just the names that appear on the screen. So if I'm just using your first name, it's just because I'm not remembering everyone's last name. So please excuse me for just, you know, being informal. I don't mean to be. Bridget.
Thanks. Yeah, I just wanted to, Justice Tuger just said most of what I was going to say, but just to kind of set the tone for why we kind of struggled with this number two. You know, we kind of, for points that you raised, Wendy, and for things that were in Brady's memo and things that Tom raised too, we are starting off here by not wanting to rely, as they are in Utah, solely on philanthropy for the startup costs. We're also trying to, and so we threw around like, well, can we just ask the legislature for, you know, funding for general fund money so that we can have a stable source of income for this, and that's not conflicted by, you know, whoever's giving us the money. But also I was hesitant to put that in because that's just not the way that regulatory agencies are funded in California. The way they're funded, as Justice Tuger mentioned, is through licensing fees. But these regulatory bodies have been in existence for like, you know, an entire century, like the medical board or the bar, where, you know, this is something that's been happening for a long time and the infrastructure is already built. So here we're trying to build a new infrastructure, but we don't want to just tell the legislature, well, you should give us money for this when it's totally different from how any other regulatory body is funded. So we're trying to recognize that. We're trying to get to a point, you know, state our intention that eventually it would operate as a regulatory body, just like other regulatory agencies. But to start, we're hoping that we can work with the legislature in proposing something, Wendy, to kind of answer your question, that they are willing to fund, and that kind of remains to be seen, right? We have to build it. We have to give them the data. We have to give them, you know, what our proposal would be. So obviously we don't have that all fleshed out here in number two, but I just kind of wanted to point out some of the nuances, and the reason that this is worded the way it is because there are kind of a lot of, you know, different details involved in the different funding sources. I don't know if that helps answer your question or not, but that just kind of give you some insight in why we drafted it this way.
Thanks, Bridget. David?
I think Micah's in the queue before me, so go for it, Micah.
Okay, thank you. Micah?
Thank you. We can suggest that an independent regulator is appointed, but the participants of the Sandbox are exempt from these regulations. So the legislature might want to have a say in that, especially if we're suggesting that a majority of the funds that are meant for schools are being redirected to fund this entity. Under Prop 98, a significant amount of general funds goes to schools. So there are additional political issues inherent in any sort of ask about general funds money, particularly with the unions in the state of California, which are very strong and have a lot of influence in the Capitol. So I think that this, this concept and number two needs a lot more deep thinking on it, because I think it's a hard ask for general funds.
Micah, can I ask you to say a little bit more about that? Are you talking about general funds as opposed to some other monies the legislature would choose to give, or are you saying asking for public funds at all?
I'm saying asking for public funds at all. There's steep competition for the limited amount of funding we have. Our courts are underfunded. Schools, like I said, under a proposition passed by all Californians, indicates that most of the money from the general fund goes to schools. So I don't know where they would raise funds from for this this regulatory agency, which is allowing people who are unregulated to participate.
Got it. I just wanted to make sure I understood your comment. Thank you.
David?
I think I'll end up echoing some of Kevin's comments from 10 or so minutes ago, which I thought were really excellent. But I guess I'd like to say that I'm wary of a resolution and maybe an ultimate recommendation that sets an expectation of a primarily applicant-funded approach. And I think the problem is structural. I think it's fundamental to what the Sandbox is about, which is spurring innovation. And that also makes it fundamentally different from medicine or from what the state bar does. And just very concretely, I think applicant fees that are large enough to support the kind of regulatory and in particular data analytic presence that I think we're going to be comfortable with will necessarily depress innovation and will necessarily depress the innovative potential of the Sandbox. And so if I were doing this, and this is ultimately going to be up to, this is well above our pay grade, this is going to be a legislative decision. If I was going to craft a resolution or an ultimate recommendation, I might craft it far more generally and say ample funding is necessary to support what we think will be a fairly substantial set of regulatory and data analytic tasks. That could come from general funding. That could come from applicant fees with appropriate supplementation. But I guess just to return to where I started, I worry about setting an expectation that it's going to be applicant funded or applicant fee funded. I just don't think that's going to produce a pool of resources that are sufficient. And if it does, it is going to have that innovation depressing effect.
Okay, great point. Andrew?
Yeah, I just wanted to say, for what it's worth, I think part of the problem that I think we're running into as well is that there are some things about what the goals are here and what we're all doing and what our belief as to what we're all doing here that seems to kind of be separate and apart. And I think in some ways it might even be helpful to kind of review mission, vote on that, goals, vote on that before we get into the nitty gritty here. Because I get a sense from the comments and the way we're all going through this that we're almost using these edits as kind of proxies for our individual beliefs as to what's going on, rather than us agreeing as a group. It's going to be a tough conversation. I think we're dealing with a lot of different views here, and all of them have a lot of merit, pros, cons to everything. So for what it's worth, I think in some ways doing this might actually further confound our efforts based off of tough conversations that we probably have to have.
And Andrew, good point. Is your observation, does that encompass all of proposed resolution 2 or just that last sentence?
No, it would be all of it. And I don't want to be a person who sits at the back of the class, puts up their hand and makes things tough. That being said, what I would say, just being part of, ATOs in the past, but also different groups, I think right now, as everyone knows, what we're talking about is just so charged. And you even heard that from the comments at the beginning, et cetera. But I do think as a group, we probably should determine what our goals are here overall, what we're going to be open to, what we're not open to. And the reason why is that it'll directly impact this work that we're doing right now. So for example, if we say, hey, we're going to put forth in our suggestions the ideal situation and put that in front of folks and the decision makers ultimately to decide on things, that would change the way that we discuss even what we're just discussing right now in terms of the funding. Because in some ways we can make suggestions as to the funding, but we ourselves aren't making that decision. So I think, I hope I'm making sense, but what I guess I'm suggesting is we might want to have some of those tougher conversations up front and then return to this task, because I think this task would probably be much quicker once we have an understanding and a collective understanding as a group as to what we're doing here.
Okay. So we've had a lot of discussion about different aspects of this. There are a couple of possibilities. One is we could move on to number 3 and, recognizing that we're not voting on this right now. 2, if anyone wants to propose changes, that's obviously we're open to that. I think that I would, unless there's more discussion of number 2. Irma, Judge, and I can't remember your last name. I apologize.
That's okay, and feel free to call me Irma. I'm just wondering if we could complete the discussion, after we complete the discussion of everything, if we have suggestions on changing the provisions that we've already covered, if that's still possible, because it may be as we go through, we'll see something that we need to change in number 2, or that we should change in number 4. I don't know, but I think it's better to go have a full understanding of the direction we're moving in before we try to finalize language. So is that a possibility?
Definitely. We can, and I think that I would suggest that we go on to discuss number 3, unless anyone has any more comments on number 2. And I think, so each of these proposed resolutions, as you know, is addressing, a particular part of the charge that we were given around structure and governance. So now if we move to 3, we're talking about the role of the Supreme Court. And this is intended to address some of the antitrust issues that Brady's memo analyzes. So this is around the Supreme Court's role in supervising the Sandbox regulator making recommendations to the Supreme Court concerning the licensing and discipline of participants, and that as with attorneys, the court should reserve to itself the authority over licensure of Sandbox participants and approval of any governing principles. And lastly, that the Supreme Court shall exercise that authority as it deems most efficient and appropriate. And that's intended to, in Brady's memo and in discussion among the committee, we raised the possibility that the Supreme Court itself might delegate certain aspects of this, both to address the kind of conflicts of interest considerations, as well as, other issues, including efficiency and everything else. So this proposal is just sort of addressing the role of the Supreme Court. Does anybody, I don't know if Brady wants to weigh in on this, or anybody else on the committee? Randy.
Just one comment with regard to the phrase, the Sandbox regulator should make recommendations to the Supreme Court concerning the licensing and discipline of Sandbox participants. I think in one sense, you could say, if we're trying to parallel, since this is a sibling organization to the State Bar, that it might have the similar dynamic that the State Bar has with regard to recommendations concerning discipline. And so the State Bar can, and we have me on the line, so she could speak to this as well, but the State Bar can engage in limited low-level discipline, such as approvals, public and private approvals, without having to actually have a recommendation for discipline that is actually approved by the Supreme Court. And of course, that type of discipline would be the more severe sanctions of suspension or disbarment. But I think, again, as Justice Tucker mentioned, there'll be a report that explains these things in greater detail. But I just wanted to put a footnote on that just because it says the regulator has to make recommendations appropriately, as you say, for antitrust purposes, there's still room for the regulator to do things in the area of licensing and discipline, similar to the state bar, so that the Supreme Court isn't having to essentially micromanage everything that the regulator does. Example being the regulator being able to do things like approvals, but not certainly higher level sanctions like suspension or disbarment.
Yeah, good point. Brady, did you want to say something?
You know, I was just going to basically repeat my comments with respect to paragraph 1. This recognizes the antitrust concerns and the delegation concerns. So gives the Supreme Court the authority, while also recognizing that Supreme Court might have concerns with, you know, those 7 justices being the ones to exercise discretion in licensing decisions, and they might want to separate themselves by delegating some of that authority as they see fit. That's the explanation for the last sentence there.
Thank you. Any comments on number 3? This seems to be less controversial or perhaps interesting to us. I'm all in favor. How about number 4 then? And I'm not rushing anybody. If you wish to comment, just of course we can go back. Just going to go on to number 4. Okay, so this here we are addressing Mimi's magic here. Hang on. Number 4, I'll look at my paper instead. Number 4 addresses the volunteer board that will oversee the regulator. And so number 4 and 5 both do actually. So number 4 contemplates that this is a volunteer board as opposed to, you know, a paid board. It sets forth, you know, what the responsibility of the board is, responsibility for the operations of the office, including the same licensing and disciplinary recommendations referred to in the previous paragraph. And it also says that in addition to the volunteer board, the regulator will have a paid staff, which will handle routine operations, assessments, and monitor Sandbox participants under the board's supervision. So obviously this isn't a comprehensive list of the responsibilities allocated to the board versus the staff, but we just wanted to set up the basic structure and some sense of the division between the board and the staff. So does anyone on the committee want to address number 4? Seems, Kevin?
Yes, all I wanted to do is circle back to the issues that we raised previously in our discussion about staff. And when you talk about in 4 handles routine operations, does that include data analysis? Is that considered routine operations? Are we just talking about the staff involved in the application process? Are we going to talk about the staff involved in trying to determine what is actually going on with these entities? We're collecting their data. Is all of that going to come under the penumbra of staff? Because when I see routine operations, I think answering phones, you know, bringing, attending to people during board meetings and so forth. But I think we mean a lot more. And I think perhaps we should use a different word than routine when we're talking about this.
And that's a good point, Kevin. I would say that I don't think this resolution purports to sort of set forth a comprehensive list of responsibilities or, you know, decide how to a very specific level, all of the functions that the regulator does are to be allocated. But, you know, it does go on. It says assessments and monitoring. So I think that sentence does contemplate a larger role than just answering phones. Bridget?
Yeah, I just wanted to add, you might want to just remove the word routine, because when we're talking about discipline enforcement, that's not routine. It certainly isn't routine to any of us who are lawyers. It's our livelihood.
Yeah, and I don't think that would be part of what's routine. Routine might be, you know, setting up an application process, overseeing, you know, operation of the website, you know, understood. And we're not trying to be pejorative around discipline and enforcement. That, yes, those would not, I don't think, be considered routine, but we could take the word out at, you know, Bridget.
Thank you.
Yeah, I just was gonna say, like you, Mary, just the assessments and monitoring Sandbox participants, I think is what we meant by, or, envisioned that staff would also be assisting with that day-to-day, I guess, if you would consider that enforcement, but that's part of the data analysis to me, is the assessment and monitoring Sandbox participants.
So I guess I think now Mimi's crossed it out. I think and I've just proposed, I'm not sure that we should take it out entirely. I think to say it handles operations sounds a little vague. What would administrative operations be a better term for what we're talking about?
I would say yes.
I'll make a friendly amendment to our own committee's memo here. Okay, any other discussion of number 4? Okay, again, happy to circle back as we move forward. Number 5, this addresses, who the board is and how it's appointed. And we track some of this from the ADL's report, and then some of this comes from our consideration of, what is likely to be a workable board, and, thinking about how they should be appointed. In earlier drafts, we had, we're trying to think about what is the useful characterization of the two, different types of people. And you see here, we've got public members and legal services providers. Bridget and Eric, that was language that you, after thinking about this and about the concerns that we had at the committee, suggested. Do you want to address that?
Sure. Did you want to start, Eric, or do you want me to? Okay, I'll start. So yeah, this was our attempt to try to conform this to the way other regulatory boards are set up in California, including the bar's Board of Trustees. And we kind of got tripped up. So we're definitely open to discussion here. This was just a starting point, I guess, for a discussion with the bigger group. But initially we had, the draft had, 7 non-lawyers and 6 lawyers. And the discussion in our group was, well, is that really the right breakdown for this, this group? Because the Sandbox does propose to extend services beyond just attorneys that are the ones that are providing it. And so we came up with legal service providers as, the board members who were there that were working in the field that had, this is, by the way, separate from the conflict of interest discussion. This is just for the board, who would be on the board. And this would be just like on the Board of Trustees for the state bar, we have a certain number of attorney members. This legal service provider group would be like the attorney member equivalent on the state bar Board of Trustees. And then public members just means in regulatory parlance, just people who are not licensees or potential licensees, I guess, of the regulatory body. And then we also wanted to, though, and a lot of this came out of the ADL's recommendations, be a little bit more specific about who's on the regulatory board. We want to have a breadth of experience and perspectives. And so for the public members, we wanted an economist, a technologist, somebody who interacts with the community, particularly underserved communities, not as an attorney necessarily, but just somebody who's familiar with what needs they may have. And then also from the attorney or legal service provider expertise, the legal ethics, legal services, and court self-help. These are just kind of areas that we think having that type of expertise and perspective would be really helpful in this decision-making body as far as the policy of what the regulator is carrying out. So hopefully that makes sense. We're trying to get a broad range here and happy to answer any questions.
Any questions or comments on this piece?
I have a comment. In some circles, the term legal services providers is regarded as synonymous with legal aid lawyers. I'd rather use the term attorney members.
I hear you. And so this is where we're struggling because, you know, you mentioned this, Jim. I mean, we use it in two different ways in the same resolution now that you point this out, because I think at the end, at the very last sentence, when we say legal services, I think we do mean legal aid people. I keep going back to the fact that we don't necessarily want to limit this to attorney versus non-attorney as far as the composition of the board, if that makes sense, because the services that are going to be regulated are contemplated, I think, to be beyond that. And I just don't know how to, we ended up, maybe Eric, you have something better to say, but I think we ended up landing on legal service providers, maybe just because that's what the broader description of what is proposed to be in the sandbox, but definitely open to suggestions.
Just to highlight for everybody that the issue we're facing is, that if we were regulating, say nurses or something like that, this would be, 6 nurses and 7 non-nurses. But here we're contemplating a situation where there might be people providing legal services who are not lawyers under the sandbox, and they would not count as public members. So we're looking for some language that would encompass this kind of new market that would have non-lawyers providing some legal services, and hence the name legal services. But I totally follow your point that that's not, that term's already taken. We just weren't able to come up with a better one.
Kevin?
Yeah, that was the problem I had in understanding this, because one of the lines here is the governor's nominees must include a non-lawyer provider of services to communities with significant unmet legal needs, which sounds like a legal service provider. So I was a little bit confused by what were the terms, what terms you were using and what you intended to cover. And I don't know whether Jim's suggestion of saying attorneys doesn't really cover it, as you've just explained, because given the target group here, or the target applicants, there would be some legal service providers who are non-lawyers. So I'm not sure what the term is that should be used under these circumstances, but it is a little bit confusing as it's currently written.
And let me just say, and I'll call on the hands in a minute, that sentence that you point out, Kevin, a non-lawyer provider of services to communities with significant unmet legal needs, was not intended to be limited to someone who's involved in providing legal services. It's more addressing provider services to communities with unmet legal needs, but not necessarily someone who's involved in providing those services.
Okay, I misread that then.
Yeah, no, it's just, that's helpful to point out. Justice Duker?
So I like Jim's suggestion for 2 reasons. I shared Jim's and Kevin's concern about just the understandability of the phrase legal services, given that it has this other meaning. But I also, while I understand Bridget and Eric's struggle to try to find the right term for those who will provide legal services, even if they're not lawyers, lawyers are at some level the quintessential provider of legal services. And while this organization is going to be expanding that, I don't think there's a requirement that the participants in the market need to be in the minority here. I don't think they're in the minority in the State Bar Act, for example. So I don't know why it would be, I guess I want to push back on the idea that we need the group of 6 to be broader than lawyers. I understand that it can be broader than lawyers, but I don't know that it needs to be. And maybe the clarity of the term lawyer and the fact that lawyers do bring something special to the table would provide other reasons besides sort of linguistic clarity to go with lawyer on for this list of 6.
Okay, thanks. Neil?
You're on mute, Neil.
Yeah, I got it. Yeah, thanks. Yeah, I sort of agree with you, Justice Tucker, on that point. And want to just say attorney. I had an additional question. What's the how do you define an economist, and what's the thinking behind having an economist be part of the group?
And I would say that I think that was one of the ADL's recommendations.
Okay.
Do you want me to answer that?
Sure.
I mean, Eric, you might be a good person to say why economists are important or how to define them. But I think, I mean, speaking from ADL's, and Andrew, you may remember too, I think the idea behind that is just somebody with an understanding of the way that the market is working and how this regulation is impacting the market, I think is my very broad description. But again, just kind of an alternative perspective to the traditional lawyer versus non-lawyer way of looking at things.
Okay.
Wendy?
You're on mute, Wendy.
I'll try not to keep doing that. Thank you. I just wanted to briefly echo what Justice Tucker had said about the attorneys for either the 6 or possibly the 7. I think given that this is providing legal services, I do think that there's expertise and insight that attorneys bring. And in particular, whether there would be for the regulating board, a focus on folks who have regulation experience, particularly as it relates to protecting consumers and the public in this arena. It would seem to be skills that we would definitely want to ensure were brought forth for the Sandbox regulator, given that there is a wealth of experience out there, particularly at the state bar, for regulation of abuses that can happen in the marketplace and the provision of legal services.
Yeah, and that's a good point. That's something we can certainly cite in our report. But, you know, this resolution doesn't intend to direct how the, Senate, the Supreme Court, et cetera, should choose. But that is the comments that we can add in the report, for sure. Dan?
Yeah, I won't belabor the point, but I would echo and support Justices Jim and now Wendy's comments about attorneys and why that would be helpful.
Okay, thank you. Justice Tucker, do you have your hand up again?
Oh, no, I'm sorry.
Okay, no, that's fine. Just trying to do hand management here. Bridget?
Yeah, I still struggle with, I'll just put my point back on. I still struggle with the idea of just having it be attorney, and maybe I'm the last one that cares. So I won't belabor it, but I do think this is different. And the whole point of this whole exercise is to think about regulating in a different way. And having attorneys who are used to the traditional way of practicing law is particularly a majority of this board, I just think is not what, at least in my view, we should be doing. I think we need to have different perspectives, people who are innovative and looking at things in a different way, how to deliver it. I think there's differing analyses about whether having a majority of attorney members as the composition of this board presents antitrust issues. I still think it does. So anyway, I would just like to raise my concern still with having the breakdown be attorneys as, the requiring attorneys to make up either a majority or even a significant number of the members of this board.
Okay, Crispin?
Thanks very much. I think I agree with Bridget. I think that we're trying to make sure that this board has got a wide enough range of views, understanding the people it's regulating and the services that they're providing. And that, to me, leads us to something slightly wider than attorneys. And it might be that we use words like attorneys, 6 attorneys and potential Sandbox participants or something like that. But I'm equally conscious of the chair's steer earlier on in the list of resolutions, that we just have to agree the general thrust here, the exact wording, and getting better wording than legal services providers we can leave to the drafting of the final report. So yeah, I don't think we have to get the language quite right here, but I do think it should be wider than attorneys.
Randy?
So maybe there is compromise language, similar to what Crispin was just alluding to, because I do believe that attorneys, while super clear, is also super narrow and limiting, and doesn't capture the point that Bridget has been raising. And so perhaps one approach would be to say 6 attorneys or other persons or entities authorized to practice law in California. And I'm taking my inspiration from the different definition of law firm or firm in the rules of professional conduct, which refers to not just individuals, but also organizations authorized to practice law. And so this could, oh, go ahead.
Sure.
Sorry.
But we are talking about a board. So how would an entity be eligible for appointment to a board?
There could be, I suppose, a law corporation who is authorized to practice law that might want to have a representative sit. But that would be an individual. So if you wanted to get rid of the organization or entity, then I think you still want to not have the super narrow concept of attorney. I think you still want other person authorized to practice law in California. That would encompass potentially an individual sandbox applicant, but you would be leaving out the alternative business organization that might be a sandbox participant. It would include a licensed paraprofessional if that program is ultimately implemented, because they are persons authorized to practice law. And so there are other categories of legal services providers other than attorneys. And I think the goal is just to signal that it's not just attorneys versus public members, it's market participants who are authorized to practice law versus public members. And that's just a quick shooting from the hip attempt to compromise through drafting.
Okay, Jim?
Yeah, where I started was my concern that the term legal services providers was super narrow. It was not only limited to lawyers, but to a subcategory of lawyers, legal aid lawyers. And I think we're all agreed that that was not the intention. I like the direction that Randy is headed in, but I'd propose a friendly amendment to his language. And this is going to sound contradictory to where I started, but to say 6 persons authorized to provide legal services in California. That to me I don't think that would be interpreted to mean legal aid lawyers. It could practice law. It sounds there. How about that?
Okay, well,
that's what I was going to suggest. That's exactly what I was going to suggest.
Okay. Andrew?
My hand was raised, but I will say it. I do think it's important that we don't just limit this to attorneys. And a good example is, doctors didn't wash their hands between surgeries for a very long time. And it's not because they hated the people they were performing surgery on. It's just they didn't realize about a bunch of things, including microbial and bacteria yet. I think by us limiting, and it doesn't sound like we are, and we're exploring that, I think we might be in a situation where we continue to not wash our hands before surgery.
Okay, on that happy analogy or metaphor, Tom?
I think we don't want to, we don't want to make the attorneys here sort of second-class citizens and presumptively inappropriate nominees here. I mean, it strikes me that having 6 attorneys in an area where they have expertise and they specialize in various things makes completely good sense to me. But I think I'm a bit concerned about the last sentence about the Supreme Court's nominees. I mean, my sense of this is that we're not strictly going to be concerned about legal aid. I mean, there are very specific areas of practice, family law, employment law. I think, if this could be broadened out to attorneys with experience serving unserved or underserved citizens of California, that might be a much better deal. Because we've got, as apropos of some of the folks that spoke at the public session, there are folks that do class actions, there are folks that do contingent fee practice. They know a whole lot about how to serve people, how to do it efficiently and effectively. So I think I'd like us to broaden this out a bit, I think would be my perspective, and freeing up some of that language in the last sentence strikes me as a good idea.
Okay, now, okay. Wendy?
I think Thomas's suggestion are excellent. I think that particularly focused on attorneys with an area with expertise of serving the populations that we're supposed to be targeting, I think is a excellent idea and consistent with this stated mission. Additionally, I understood that the 7 public members, that could include people of the Sandbox, which would still be a majority. So the concern about being somehow overly heavy with attorneys, well, the majority would still be non-attorneys or other persons who would be providing services. That's what I understood the 7 public members in the majority to be.
I'll just clarify real quick. The 7 public members are meant to be people outside of the of this industry in general. So not lawyers or people who could potentially be in the Sandbox, but just public members, outside people.
Justice Tucker?
So picking up on the suggestion that we revise the last sentence, what about and picking up on an earlier comment that maybe we should think about cross-fertilization with the state bar. What about changing the last sentence so that it talked about people with experience in legal ethics, which I do kind of think we should keep, providing legal services to low-income Californians would be the second, and then the third would be, I don't know how to phrase it, but basically activities and governance of the state bar. Somebody who knows something about the state bar as an organization. I don't know if it's a good idea, but it's at least a good place where we could, if we want to insist on cross-fertilization, put it. So I just, not so much as a recommendation, but as a topic for discussion, want to throw that in there.
Yeah.
Eric?
Just to Tucker, this was just rather than activities of the state bar, could we narrow it to regulation within the state bar? Because it seems to me, that the experience with the bar may be less important than the bar's regulatory function in this regard. And so I don't know if that's too prescriptive, but I'm sympathetic to the idea there is another regulatory entity, regulating in similar ways, and it would be very helpful to have someone on this board who understood, sort of the other half of the regulatory entity. It has concerned me that we are essentially setting up, 2 regulatory entities that are sort of running parallel, depending on how you enter the legal market in California if this goes through. And so I wonder if we could, sort of make that more specific.
Yes, I think regulatory functions of the state bar is much better language. Thank you.
What about legal regulation?
What do you mean specifically?
What about just broadening it to say in legal regulation, which would allow somebody who, was involved in like the discipline compliance side versus, as well as the regulatory side, it would broaden it. Anyway, Bridget?
I think, Toby, did you have your hand up first?
Oh, sorry. Oh, sorry, Toby, your hand was blocked out. I don't even see it. Please go.
See about getting unmuted there. No, I think the discussion is going in the right direction. I just had a couple of thoughts. First of all, we need to recognize that the initial board won't have any non-lawyer deliverers of legal services because presumably there aren't any until the Sandbox approves them. So we're really talking about lawyers at that point. members get replaced along the way, they could then come in. I think that the public members, I think it needs to be clear, are not participants or involved with participants in, or potential participants in the sandbox. I mean, I don't think we want, 6 lawyers and then 7 people who are employed by or involved with sandbox participants filling this board. It needs to be clear that these are people outside of the whole regulatory area. On this last point, I guess I'm not as wedded to having the overlap with the state bar. I think familiarity with regulation of consumer-facing businesses is important. I don't know that it necessarily needs to be lawyer regulation. If it's somebody who regulates other, somebody in the Department of Consumer Affairs that regulates other consumer-facing providers, as long as it's not like the one I used to be involved with, the collection agency board, where their constituents were the collection agencies and they had no interest at all in regulating the consumer, in affecting the consumers. So yeah, that's where I would come out, and yeah.
Okay.
And I'm
Thanks,
certainly
Toby.
comfortable with the legal services to low-income Californians. I think that's a good idea.
Okay, and let me just address your first point, Toby, which I think has been a little bit loose in this discussion. There will be a conflict of interest policy, a robust one that will be developed, and we haven't developed that yet. I am quite confident, and we'll all have room for input into that. I'm quite confident that it would not allow members of the board to be employed by or affiliated with Sandbox participants. So when we say market participants, we're meaning that in an antitrust law sense, and we're meaning broader, the people who are eligible to participate in the market, not literally Sandbox participants. So, Eric?
Actually, I think, Bridget, I think you were up ahead of me. So please, because we're probably going to say the same thing.
Okay, well, a couple things. So the first one is the term public members, we're using it is because that is just kind of those are the terms that we use throughout all the business and professions code to, so that's why we have that term, but I think we could further define it or whatever. I like Toby's idea about, I was going to suggest the same thing, just to have expertise in regulation and in consumer regulation in general. And then as far as the cross fertilization, there could be other ways that we could do that. Like, for example, with the medical board, they always have, like, the executive director of the pharmacy board will always come to the medical board's meetings to give a presentation so that the boards are aligned in what they're working on with respect to, like, opioid regulation or something. So we could build in something without having to have an actual member of the board that would ensure that the two different regulatory bodies are communicating. That's just kind of one of the points I was gonna raise on that. And then I like, again, I just wanted to second the language that we have now about the authorized to provide legal services. Toby, it's a good point that at least as far as Sandbox entity representatives, they wouldn't have them at the beginning, but depending on what happens with the paraprofessional track, that there could be some paraprofessionals that would be authorized, though we could have their voice as well.
Thanks, Sasha.
Yeah, I was just going to ask about, I know the court self-help folks got crossed off on that. And I just think that that's a really important voice, either that or other people in sort of that pre-legal space. I know there's one provision for the non-lawyer provider of services, but the folks who do consumer counseling and, housing counseling and court self-help, like, they see people way before they get to any lawyers. And I just think that perspective is really important. So I would vote to keep that in, if not add another person who's seeing people with legal needs long before they get to lawyers.
Okay. So I guess for right now, we've had some suggestions and we've sort of been kind of informally making them as we roll along here. Just in terms of process and, ensuring that we capture all of this, certainly before we vote. I guess I would entertain, someone suggesting, so we've had a specific suggestion from Sasha about adding back in the court self-help experience as a criterion. I'd be interested, Justice Tucker, and you did have your hand up, but you were the one who proposed the regulation of the state bar. So I'd be interested in your reaction to how it's been, amended, because you haven't actually, we've just kind of made this amendment as it's rolled along. You haven't commented on it. So I guess I'd like some input as to how people would like this amended, for both of those two. I think it seems like people are generally in favor of the amendment around legal services to low-income Californians, but I'd like some input around the regulatory piece and then adding back in the court self-help experience. David? Oh, sorry, Justice Tucker.
Well, I was just gonna say, since you asked for my reaction, I don't have a strong feeling about whether we have legal regulation of lawyers, whatever the language previously was before it got changed here, or something else. But I do think we need to be clear. That is, I don't care whether or not we keep the state bar in here. I'm not going to argue that that's something we really ought to do. I do think it's important that we have fewer designations for what the slots have to be than we have numbers of slots, so that we're not trying to micromanage every single one of those slots. And I think it's also important that we think about whether it's the designation belongs on the lawyer or on the non-lawyer side. So the point that Sasha just made, to the extent that we're talking about providers of services to consumers before they reach lawyers, that would sound like somebody who would be on the governor's appointment side, because it's not a lawyer appointment, rather than someone who would be on the Supreme Court side because it's a lawyer appointment. Maybe I misunderstood, but as we formalize, if Sasha wants to formalize a specific proposal, I would just point out the importance, I think, of distinguishing whether we're talking about a lawyer or a non-lawyer slot.
Thanks. Just to follow up on that, how was it initially intended, the person with the court self-help experience?
Originally, that was going to be a lawyer with court self-help experience. Okay. And we took that person out, and we could put that person back, or I thought it was a good point that somebody made, that actually there are lots of other kinds of lawyers who have experience serving low-income Californians other than through the self-help center. So the low-income Californian slot here could be filled by somebody who had self-help experience and was a lawyer, or had legal services experience and was a lawyer, or was a consumer attorney and was a lawyer. That would be up to the Supreme Court. Or they could, pick 3 of those people and just use the slots other than the ones that are specifically designated.
Eric?
Sasha, just to go back, when we had originally drafted this, and Bridget, feel free to jump in, we were thinking of kind of the expertise of the people on the panel, one being a person who was not a market participant, but understood sort of these unmet legal needs through, sort of their work in some non-legal services providing area. And then the second was much more specific, people who were providing sort of legal aid. And I guess just to as we've removed the second one from, that person would still be a market participant. It would just be a segment of the market that was, nonprofit typically, right? So I think that's the way we were initially conceiving this. I'm fine removing the legal services provider component of this. I do think it's personally, I think it's kind of important to keep the broader perspective in the public members. Just because the idea here is, part of the charge of the committee is to provide, legal services to unmet legal needs. And the thought was that someone on the committee, should sort of speak for those interests and have a broader understanding. I think that was the idea of it.
Thanks.
David?
So I have three quick points. First is a scrivener's point, which is, could we move experience up? Could we say individuals with experience with legal ethics, legal services, et cetera? That seems to read better to me.
I like it.
Second point, and this focuses in on that non-lawyer provider of services to communities with significant unmet legal needs. I think I've lost the thread a little bit, but I initially read that to be a non-lawyer provider of non-law services. So I think when Toby first spoke, I think he was talking about that clause, and the suggestion was that, well, those people don't exist yet, because at least don't exist in large numbers yet, because the sandbox doesn't exist yet. But I read that phrase differently and see real power there. Like I would think of that as like, you know, a physician who provides services to a population with unmet legal needs, or, you know, someone who provides financial services to folks with unmet legal needs. So, you know, someone who helps folks sign up for EITC or something like that. And I think there's real power there, and I think that's very consistent with, you know, Bridget's really well articulated notion that we want to have as expansive of, I guess maybe Randy too, but as expansive of, you know, a set of Kens as we possibly can with the people who populate this board. So I really like that. I hope it stays in. And again, I've lost the thread, but if we were thinking of changing that, I don't think we should. Third point, maybe I'm over lawyering this, but is the notion of a public member, is that preclusive of a legal service provider? Could the governor, could the governor picks just, you know, be lawyers through and through, people who provide legal services, or is there some sort of a hard and fast distinction between public members who are defined as non-lawyers, and then the, you know, on the one hand, and then the legal services providers on the other? You know, if that is the case, I think we need to make it clear, and maybe we need to make it clear in any event.
Yeah, that's an antitrust issue. Bridget, I think you or Brady, you are our antitrust people here.
It's just public members is just used in all of the different regulatory boards just to mean non-licensees is usually how it's used. It's a little tricky here because these are all new people, right? But it's kind of just used universally as people who are, you know, in the nursing board, not nurses. So it's just that we're talking about such a wide and new range of services here that makes it hard to make it concrete in your mind, but it would be understood. I think if this were to be put in statute, it would be understood by the governor's office that he wouldn't appoint a lawyer to fill that role. Does that make sense?
Toby?
Let me clarify that. I was not talking about the community person there in my earlier comments, but on that one, the way I've read that, the way I read it when I first saw it, was somebody working at a community center, somebody working at a community organizer, at a neighborhood center that is hands-on, specifically dealing with low-income people. I never perceived that as being a financial person or a doctor or somebody. I saw it more as a grassroots kind of person.
In any event, though, I think we all agree it's not a lawyer.
Right.
Right, and we did draft it broadly to encompass both of the types of, all of the people that you both have raised. At least that was my intention. I think maybe Eric, you agree with me. It is just meant to be somebody who's not a lawyer who's engaging with this community in general in some way.
Brady?
Just to join in here on the last legal regulation of the state bar, do we really just mean regulation of the legal profession? Is that what we mean? Because otherwise regulation of the state bar sounds like the people who are actually in charge of regulating the state bar, which
Brady, I think that's a half revised thing. At one point we had regulation of the legal profession. Before that, we had the idea that it was someone involved in the state bar's regulatory activities regulating lawyers. And then we had a suggestion that actually we don't need and perhaps should not have either of these. There was some idea we should talk instead about regulation of consumers. I think, we should also consider just leaving off the third category. Perhaps at this point, my recommendation, I don't know, I'm not going to have a recommendation, but we should at least consider leaving off the third category and only designating 2 categories for the Supreme Court, understanding that the Supreme Court will fill the other 2 with whatever they think the bar most needs at that point, whether it's somebody who used to be involved in regulatory activities at the state bar or used to be involved in regulating at the medical board or, whatever all else.
I like that recommendation myself. And don't forget, we can talk in the report about the kinds of expertise that might be helpful in terms of, potential board appointees. Tom?
Thank you. Yeah, I agree with Justice Tucker about this last piece. I mean, I think stepping back from this, I think the state bar experience is not that important. I mean, what you would probably want paradigmatically here would be somebody that knows how to enforce the law. How do you investigate things? I mean, prosecutor might fit here, somebody else might fit here quite nicely. But I think, the 2 that really stand out here, experience with legal ethics and services to low-income Californians, I think is really enough. Because I just agree completely that state bar experience is just not that crucial, frankly. I mean, it's such a unique deal that, I'm not sure that it's really what specific expertise you would want to bring to that part of the board.
Thanks. Judge Irma?
I encourage leaving in the words regulation of the legal profession. As you all have been discussing matters, I want to come back to the point where we're talking about is having something that's going to provide innovative ways to deliver legal services. And I think those individuals that have been involved with regulating, and Tom made the point, it could include a prosecutor. I think it's important because it's helpful that, at least to me, it would seem helpful that our board would include people that are looking out are the providers, the members of the Sandbox, are they, and excuse me, I'm not familiar enough with all the terms that you all have used, but I am learning that the participants in the Sandbox would be people that are providing good legal services. And I think if we start moving away from looking at a board that is not going to include members of the legal profession or people who have some understanding of what it is that you should do to make sure an individual is getting good representation, whether it's completing documents or participating in an actual court proceeding. I think if we lose sight of that, of having folks that are overseeing that, I think we do a disservice to the community.
Okay, thanks.
Justice Tucker, Mary, we are coming up on 12:15. I just wanted to note that.
So everyone, at 12:15, we have a speaker who's going to be joining us, so we'll be adjourning. Justice Tucker, we still have one more item to discuss here. I think we can probably leave this pending question of the specific language of paragraph 5 for a bit. We can adjourn now, and if you want us to afterwards to just finish up this discussion, that would be fine.
I apologize that I didn't jump in sooner. Tom, do you think that our speaker would accommodate us taking a 5-minute break and coming back at 12:20 to have you introduce our speaker?
I assume he would, but he may be standing by. I thought he was going to join us and be in a waiting room, but maybe Mimi could tell me what the deal is.
I'm looking for him on my list. Give me a second. It's a long list.
Yes.
Mihir.
Mihir,
Hold on.
Kshirsagar.
There you go.
Why don't I just make
Mihir?
an executive decision since we haven't taken any breaks yet? We're going to take a 5-minute break. We'll come back at 12:20 to have our presentation, which should run about 45 minutes. Then we'll take a longer break, half-hour break for lunch after that.
I'll email Mihir right now.
Well, Mihir is with us right now.
Oh, he is. Okay.
Yes, and I've promoted him to a panelist. So Mihir?
Mihir, in 5 minutes, we're going to introduce you and start, but we
ran
over,
yep.
So we apologize.
Okay,
but we'll be back in just a few minutes.
Got it. Yep.
See you in 5. Thanks.
Bye-bye.
Thank you.
And I want to apologize to our guest speaker for the short delay. We are really eager and excited to have you here, and I'm going to ask Tom to introduce you formally, and then I think you have some comments and some slides, and then some time to respond to Q&A. So I'm sure that people have a lot of questions and comments they want to raise after you've concluded your remarks. Tom.
Thank you. And let me welcome Mihir Kshirsagar. Mihir is the director of Princeton's Center for Information Technology Policy. So at that venue, he does research and teaches on various questions concerning information technology. So he's going to talk to us today about what are called dark patterns and artificial intelligence and its limits of various kinds. He's a former Assistant Attorney General for the state of New York, where he was in the Bureau of Internet and Privacy and led a group of attorneys that settled, I believe, the largest privacy case, certainly in the history of New York and maybe in the history of the United States. He's a former associate at Cravath. He went to Harvard College and went to law school at the University of Pennsylvania. And I've had the great pleasure to work with him on the State Center Board. The State Center is an organization that provides money to state attorneys general to improve their ability to enforce the law. Mihir has been doing programs for state AGs on dark patterns and their implications and how prosecutors should step up to the plate and deal with those things. So Mihir, over to you.
Thank you, Tom. Thank you very much. That was very, very nice of you. And it's a real pleasure to be here. I'm going to share my screen. So I hope everyone can see that. Yes?
Yes.
Great. Excellent. So yeah, I'm at CITP. I run a clinic. I'm in charge of a clinic here at Princeton, where our mission is to understand and improve the relationship between digital technology and society. And my background is really not necessarily in computer science, but I sit in the computer science department and I advise and teach students on ethics and things like that. So today I'm going to be talking about two particular risks that come up when you're thinking about using computer-assisted legal services, especially to address the areas of the justice gap that your working group is looking at. And one of them is this concept of dark patterns, which I'll get into. And then the second one, which I provocatively titled AI hubris, but you can also just think of it as, does the tech actually work? And so that's something that I'm going to be talking to you about. But please feel free to interrupt me, at any time with any questions. I'm going to reserve time at the end for questions, but if there's anything that doesn't make sense for you in the middle of it, please interrupt, just raise your hand or just unmute, and I'm happy to take that. So here is a definition of dark patterns. It's actually, I've written a paper on how dark patterns are not susceptible to a definition, a neat definition, but here's one that we used in a paper. And I think the key words to focus on are that they're interfaces that benefit an online service, and they lead users to make decisions that they would not otherwise make. And so it's disturbing the autonomy of user choice, and it's presenting information in front of users that they don't, that making them select things that they would not otherwise do. And so in the academic community, there's actually been a lot of research on trying to identify the different kinds of dark patterns. And so mostly this research is focused on identifying the different mechanisms that are used for dark patterns. So, trick questions, or sneaking something into your basket when you're not expecting it, or the roach motel, which is, it's hard to get out of this, out of a service if you signed up for it. So there are various times, taxonomies. Here are two presented here, nagging, constantly reminding you of something until you just have to accept it. I'm sure all of you in one way or the other come across them in your day-to-day lives. But these dark patterns are proliferating. Of course, this is an area that has caught the attention of regulators. In fact, California is at the forefront of this, comes as no surprise, and has, in fact, the Attorney General's regulations on privacy have something to do with how the quality of the consent that you obtain, if you've used a dark pattern to obtain consent, that could be problematic because you really don't have the informed consent of your end user. Here are some more examples of dark patterns, and I'll get to describing why dark patterns, I think, are a particular issue here when you're thinking of legal services for the underserved populations in California. And this is from the New York Times, and it has a few examples of how websites might, for example, sneak things into your basket. You're buying an internet domain, you click yes, and then you're about to pay, and then all of a sudden it's adding extra services that you don't fully understand to your to what you had anticipated. And so you're spending a lot more money than you originally thought. Similarly, there are ways in which you can collect information from people and get them to turn over information that they didn't intend to, in the friend spam example that's up on your screen. Or of course, you have the bait and switch, which is quite familiar to some of us. So let me talk through 4 specific examples of dark patterns that exist today to give you a sense for where the problems are. So I don't know if any of you have tried to delete your Amazon account, but if you haven't tried it, it is an amazing maze. And I had a little video that was it took 5 minutes to, in a video, describe how difficult it is to cancel your Amazon account. Basically, it's very, very easy to sign up for the Amazon service, but if you wanted to leave Amazon, it is incredibly difficult. And actually, the same thing for the New York Times. If you want to cancel your New York Times subscription, the only way to do that is to actually speak to a real live human being. You can't do that by signing up and just clicking a few buttons. Much like, but coming into the service is very easy to do that because they want to get your money. But when your money is leaving, they make it very difficult for you to leave. And the FTC recently took an action against a kid's game called ABC Mouse, where essentially people were locked into recurring service plans, and they used a variety of dark patterns to force parents into continuing to sign up for these services that they didn't really want to sign up for. Another example is the Ticketmaster website, where there are all kinds of bundling with different kinds of insurance that are added to your ticket at the last minute. So you think you're paying $20 to go listen to a concert. When you see all the fees and services after they all added up, it could be many times that price. And you've already locked in, and there's a timer on there which shows that there's a certain amount of time you have to buy the ticket. It's a scarce item. And so it pushes you into buying all these additional services that perhaps you would not have bought had you fully understood what was being offered to you. And I should say that not with Ticketmaster, but with certain other shopping websites, we've actually seen examples of companies that have faked essentially the timer and have faked the, if you've looked at travel websites and it says, 50 other people are looking at this deal, we've seen sometimes that in the script, they've got a random number generator between a certain number to tell you, 30 people are looking one time and 40 people are looking the other time. They know that this is a psychological ploy that is very effective in converting users into customers. And the final example that I want to focus on is the TurboTax free service. And that's actually something that the LA city county office is going after TurboTax and Intuit for misrepresenting this to users. And if you think about the TurboTax service, that is in some ways the kinds of legal services you might imagine serving an underserved community. And TurboTax was required to offer a free option to its consumers to pay their federal taxes. And so TurboTax did the bare minimum. It had a website in which you could do that. But then TurboTax deliberately hid from everybody else on the internet that this website was available. So when you went into Google search and you typed TurboTax free service, you could never find the free website. So essentially buried the website, made it unavailable to consumers. And at every point with consumers who came on, they didn't identify that there was this required free option. The IRS had required them to make the service available. They took the advantage of the consumers as they came in to pay for tax preparation software at a much higher rate than they were otherwise would have spent. So one of the things we've looked at CITP is to try to figure out, well, how do these dark patterns work, and what, where do they cause a problem? And we have this paper called "What Makes a Dark Pattern Dark," and we've sort of put it into two different kinds of ways in which it modifies what we call the choice architecture. So one is, does it modify the decision space? And there are a few different ways it can modify what's presented to users. So it can present use choices as unequal choices. It can eliminate certain choices that should be available to all users. It might treat some users differently from others, or it might just hide some of the mechanisms that it's using to influence users. So that's one type of dark pattern we see here. And the other one is manipulating the information flow. So that's, say for example, and this is the classic, this would be fraudulent, but affirmative misstatements or misleading statements or omission, but we see examples of that. That's the deceptive, or the information hiding, so that you present information much later in the process when somebody's already locked in and it's difficult for them to then make a different choice. They've spent a lot of time entering a lot of information, and at that point, you're adding all your services, you're adding all your fees. The consumer's at the point where they're not really capable of processing all the information that's being thrown at them. So you might say, what's the big deal with dark patterns? We encounter some of these in the offline world, and I think there are two things. One is, yes, we do in fact encounter them in the offline world, and that is in fact a feature that we thought originally, or at least the utopians, tech utopians, thought the online world would ensure that all prices were transparent, the markets were competitive, that everyone would understand all the services they were getting. Of course, we've seen that that's not true, that the online world can be a very manipulative space. And one of the reasons why the online world is such a manipulative space is that it enables what computer science and computer engineers use is called A/B testing at scale. And A/B testing is essentially just presenting two options and seeing what sticks. But they're able to do this on millions and millions of people without really knowing, showing subtly different ways of showing the mechanisms for pricing, different ways to showcase, or even color choices, and different ways in which they can see, well, does this improve our revenue by presenting it in this way? And they're able to run this again and again and again. And they're using machine learning, which then uses data about how the consumers have interacted with this software to shape how information is presented to consumers. And so we're really seeing a very different kind of manipulation going on in the online space than in the offline, because of the enormous amounts of data that's being generated through these interactions and the ways in which consumers can not really understand how much the service knows about them or people like them, and are able to flip particular cognitive switches for consumers in ways that are not transparent to the consumer. And typically we rely on the markets to fix this. But here, the self-correction mechanisms are limited. One of the problems of the different kinds of services out there, they all employ things differently. There are lots of one-off interactions. So, I'm not constantly buying plane tickets, so I'm not as aware of all the ways in which an airline might be trying to trick me into buying something I didn't want to buy. And the truth is that these patterns are very effective. There was a study at the University of Chicago where they were able to show that you could earn 4 times as much revenue by just running some of these dark patterns. And so the service providers have an incentive to use these patterns. Sometimes you rely on service providers sort of calling out others. The honest broker will tell you, hey, the other guy's a bad guy. That's not really happening here because there's a lot more revenue that comes in. So when you think about that, for the legal services market, what does that all mean? So we're dealing, from my perspective, we're dealing with, and I read this wonderful study you put out last year, you're dealing with a highly vulnerable population. You're dealing with people who are looking for services at a particular moment of particular vulnerability, right? I mean, most of the times people are going in, they're really in a dire strait, and they're looking for help, they're looking for advice. And you have this fiduciary relationship where the legal service provider has to take that into account. What happens when now this is a service provider who is an online service provider? How will they account for these factors in providing the service? And what are the concerns of dark patterns can fall into kind of two areas as I see it. One is that the legal service provider exploits this unequal position. So they're able to exploit the fact that somebody's coming to them as a trusted provider to suggest services they don't need, or to use data from the consumers in ways that the consumer would not have expected. Or they're exploiting the fact that they have a lot more data on a variety of consumers and are able to figure out how best to monetize those interactions in ways that the consumer doesn't understand. And of course, there's the potential to exploit just the situation of somebody coming to you in a moment of desperation. They're not necessarily going to be paying close attention to all the check boxes and all the queues and all the requirements that they have to fill in, and so may not fully understand what they're signing themselves up for, what they're giving up, and things like that. So in a separate world, you see that sometimes you throw people into arbitration agreements and things like that because they're in a situation where they just want to get through the process quickly, and you might be turning over very valuable rights, but not really understand that that's something that you're doing. And the effect, the other bucket of sort of thinking about this is what's the effect of all of this? So it can disrupt the consent so that you don't really have informed consent. You can make services more expensive by adding something. So, for example, if you have a lawyer who offers to an online service that offers to help you with your real estate, and then has an arrangement with an insurance provider and wants to bundle the insurance provider's service, you might suddenly wind up paying a lot more money because you're also paying for this insurance that you didn't want to buy, but now your legal service provider is telling you, hey, you should buy this insurance, without disclosing that there's this tie and that these services that they can benefit from. And finally, the last one is just misusing the sensitive data. So there's a lot of data, very sensitive data that they're picking up about people's families, people's situations, and things like that. And they may sell it to other parties or find other ways to use that data in ways that the person would not have consented to if they had properly understood. So these are some of the concerns with why dark patterns are something that legal service providers have to be, if they are going to be online service providers or digital service providers, here are some of the risks that might come with it. So what can be done? And the good news is that there are user-centered design principles out there. You can demand them. And the flip side of the data is that you can actually examine if, in fact, the service is operating in ways that were not anticipated. And so you can look through the program and figure out, okay, this particular design was used because it increased revenue. There was no other reason for it. It didn't actually improve the user experience, but it was done to benefit the service rather than the user. And that's something that you can go back and figure out from the data that was generated through these processes. So number one, you can demand these design principles and look to examine if in fact these services are behaving appropriately. The second is to look at the business model of the company in question, right? We've all seen this now with ride services or with some of the others, that does the venture capital model money obscure the true strategy of the company? And that, how is the company going to charge for services? Does it plan to make money through advertising or sharing of information? Does it depend on bundling deals that's really the only way it can make money and make a reasonable profit? So examining the business model is, I think, very, very important from a gatekeeper's point of view of what kinds of online services should be offered. And then the last thing a gatekeeper can think about is, what kind of mechanisms can you have to ensure that there is transparency and accountability built into these services when they're offered? How do you ensure that they collect information about how they function so that then you can actually examine and ask these questions and it's not obscured from you? So that's the piece on dark patterns. And I'm now going to switch gears and talk about AI hubris, but let me stop for a second to see if there are any questions thus far. Andrew.
Hi there. So I just was thinking through as you were presenting in terms of dark patterns. Oftentimes folks who interact with the legal system, the old adage is, I heard the lawyers talk and I don't understand what they were talking about. Is that a form of a dark pattern as well in terms of like complex language structures? That could that be an offline version of a dark pattern?
Well, some of it might depends on the context. Yeah.
If you sign a retainer letter and you don't understand what it means, would that be kind of like a dark pattern?
Sure, if the retainer letter was written to deliberately obscure the information from the end user, right? And was so there is a little bit of intention here where something may be obscure to the end user and has to be transparent so they understand what they're agreeing to in the retainer agreement. But there's also, a question about whether the in this case, for the retainer agreement, there may be certain requirements from the state bar or somewhere else that says you have to have certain clauses in the retainer agreement. So that wouldn't necessarily be a dark pattern, but it would be a hurdle to transparency.
Okay.
Yeah, it's hard for me to figure out with my windows open who's up next in the chat. So I don't know how I should moderate.
Randy, do you want to go next, and then Mary, and then Marta? Those are the three hands I see raised.
Sure. Thank you very much for your presentation. I'm glad it's going to be a nice interactive conversation. In terms of a regulator's perspective for finding ways to avoid dark patterns by new service providers, does this regulatory effort trigger First Amendment commercial speech protections? Because we have found, as the state bar, for example, when we do rules of professional conduct, if they implicate First Amendment rights, including commercial speech, that we have a pretty high bar of persuasion to recommend those types of regulatory standards.
It's good. It's a great question, and there are some First Amendment implications. I think if it's a requirement for a service provider coming in to provide a service, and you're the one deciding whether or not to provide, whether or not to accredit a certain service provider, I don't really see as many First Amendment issues there. If, for example, you require the presentation of certain kinds of information for informed consent, I understand that some providers might challenge that, and I should say is I did represent. I have a background as a First Amendment lawyer as well, so I can definitely see on the defense side. So I can definitely see the argument, but I think in this particular context, because you're saying that to be a service provider, here are the ways in which you've got to be transparent, and here's the ways in which you shouldn't take advantage of the consumer, I don't see as many First Amendment issues there.
Thank you.
Mary. Mary, you're on mute.
Thank you. It's very interesting. Thank you for doing this. With respect to the slide that you were just covering about the legal issues, I just have a couple questions. One is, these, I think, were presented as concerns or risks. Do you have data to show the extent to which these things happen, and particularly to what extent they happen in a regulated environment?
There are places where they're being studied. I guess, you know, we'd have to think of an analogous regulated environment. And so let me put it this way: you see some of these dark patterns in tax preparation software, which would be, it's not as closely regulated, but that is a somewhat regulated environment. And so you can imagine if there are these kinds of dark patterns on those kinds of sites, you can imagine that coming into the provision of online legal services.
But I guess what I'm trying to, because there are many online legal service providers right now. So is this slide suggesting just like hypothetical risks, or is this slide reflecting actual experience in the marketplace, and particularly again in a regulated one?
Yeah, so this is the hypothetical risk. I haven't gone out to look at the different legal services providers and seen you know, what they have done or haven't done.
Okay, thanks.
Marta.
Hi, and thank you very much for coming here today, joining us. And this is really, really insightful what you're sharing with us. I just wanted to ask, how would a regulator monitor for dark patterns or practices that are going on? I guess that's my first question. And then the follow-up question would be, we're all familiar with system upgrades and, you know, that kind of thing that happens to certain software that we all use on a daily basis. How would then a regulator monitor for those kinds of things where maybe the entity moved into the sandbox was not using dark practices or patterns, but then, you know, in certain system upgrades that might have creeped in? How is that monitored?
Yeah, those are great questions. On the first one, how do regulators monitor this? You know, to date, there's been very little proactive regulation. So there've been some reactive steps like the FTC taking the action against ABC Mouse, and certain state attorneys general have other ongoing investigations that involve dark patterns, but it's usually after the fact, right? Consumers have come in, they've complained that they've signed up for services that they didn't intend to, and then the provider says, no, I have the informed consent. And then you go back and you figure out, well, here's the path that they laid out for somebody to get informed to if they agreed to a service that the service provider wanted to sell, here's the path that it takes to get to a service where the service provider makes less money, and look how unequally they presented that information. That surely there's no good business, you know, there's no good reason for that. So proactively trying to examine whether the service provider has used appropriate design principles is something that hasn't yet come around, but I think it is something that I think if you require, you know, you've seen this in other fields. So, for example, the CFPB has that one sheet that you're required to present information when you enter into a mortgage now. And you're meant to provide very clear information to consumers about what they're signing up for. So you're beginning to see efforts for greater transparency and focusing on what the key terms are. In terms of sort of the system upgrade question and the fact that this is a moving target, that's unfortunately the nature of these systems. You do have to pay attention to how they're evolving. And I think as a regulator, you can think about sort of developing mechanisms for audits or something else where you can go back periodically and examine whether the provider is living up to the things that they promised to do.
So if I'm understanding you correctly, there really isn't a way to look at the development of the AI on the front end. It's only a post user experience where complaints could come up that would have to be evaluated.
You would need to, I think you would need to look at how they've created the particular software interface, and you would need data on how consumers have interacted with it, I guess. So it requires some examination of how consumers have interacted with the data, but you can also proactively require for certain things to be made more transparent upfront, right? So that's the other way you can think about it, so that you present, let's just say, you didn't want anyone to sign up for a bundle service. You could make very clear that you can't do that, so that you can put some guardrails in, I guess.
Okay.
I hope that, yeah.
Yeah, I think that answers the question. And who would, if a regulator isn't a technologist, so to speak, and doesn't know this area, who are the experts that a regulator would consult with to examine the software on the front end to see if whether or not there are dark practices or patterns involved?
So this is an evolving field, and there are some entities that are coming around that offer such services, and I think there are some of the audit firms as well have started to think about this service and started to offer checks to alleviate regulator concerns. And so I imagine that some combination of that type of thing will eventually come about in this space. But this is very much an emerging field as to what to do and how to think about these dark patterns.
Thank you.
Wendy.
Thank you so much. I appreciate that. I think this topic is fascinating, particularly as we're looking to change how we understand providing legal services. I've been lucky enough to represent employees who are international and national experts in ethical AI, which I think is also what you're talking about. An ethical AI, who, for folks who are not knowledgeable about that particular area, it actually looks at the front end. So are you creating code? Are you creating systems that bake in bias and bake in other issues that I'm sure none of us here would be excited to have promulgated in the legal marketplace? You can see, for example, Google had an ethical AI team, as well as many other large tech companies, and of course they're regulated entities. So in terms of having ethical AI in the marketplace, I haven't seen that to be a First Amendment issue to ensure that we're not baking in bias into the products that are then utilized in the marketplace. Another issue that I think that you raised that is extremely important is having waivers of constitutional rights that consumers are not aware of when they're utilizing these products. So for example, you use the example of arbitration clauses. We've seen this in the consumer area to ban collective action or class actions. I think that's really important regulatory, is that if folks are going to be taking advantage of some of these products, assuming they're approved, are they inadvertently waiving constitutional rights, and are they doing so knowingly? Usually those things are click, and you don't even know that your constitutional rights have been waived. That's a deep concern of mine. Another deep concern that you also talked about, which I think is really important for us to explore before we would approve anything in this arena, is who has access to sensitive data. The commodification of data is a huge issue in tech and generally with consumers. I'm very concerned as an attorney. I have duties to my clients for attorney-client privilege and work product. There's no way that I could share any health data, or frankly, even that a person is a client of mine unless it's filed, let's say, in court. And so data mining, how that's going to be commodified, how that's going to be monitored, and who collects and maintains that, and in what capacity, I think are issues that you've raised that are extremely important, particularly if we're thinking about the consumer and of these legal services, and protecting particularly those folks who are in underserved communities who may not have this sort of background in tech and understanding of some of these areas. And so I'm very happy that you're raising these issues to the group, and I thank you so much for your time.
Thank you, Wendy. I know there are a few more questions, but maybe unless it's something pressing, I'll get to this little 5 minutes more on AI hubris, and then we'll take the other questions. Does that make sense?
That's fine. And then Patricia will be first on deck.
Great. So I just wanted to quickly go over this, and I know that there are lots of questions, so I'll get through this part very, very quickly. But I think this is equally important an issue is the hubris around what AI can and cannot do. And so I just broke out from the Justice Gap study that you had. What are some of the areas that the underserved populations most need legal help with? And that's family issues, custody issues, financial transactions, immigration, and look to see, well, what kind of services are they looking for? And so some of that's the assessment of legal need. That's sort of 31%, I think, of people who are trying to figure out, do I actually need legal help or not? Then there's procedures and form filing. And then there's help in negotiations, whether it's with an administrative agency or with some other person to negotiate their positions with the healthcare provider. And one of those examples that you had, I think, of Sue, who was out of her healthcare. So those are the kinds of places where people need the help. That's really where the demand is, and representations obviously in court. And if you think about, well, what can machine learning do for those cases? It's not totally clear what those are. And so there are basically two forms of machine learning. So one is learning by example, and that's by using training data and providing training to coach a machine about the kinds of patterns that they're looking at. And then there's learning by observation, and that's a newer kind. It's deep learning. And essentially what that's doing is looking for patterns in the data, but it's, if you will, hunting for the patterns on its own. You don't necessarily have to give it exemplars and tell it what's going on. But for both kinds of learning, you need sufficient data. You need data at scale about what you're trying to look for. And you need somebody to appropriately classify it, to decide, well, what is that particular example? Is it, a particular person? Is it a particular kind of animal? Is it, variety of things. So you've seen high profile examples where some of the machine learning tools that say Google or Facebook have been used in very biased ways in terms of how it's classified people, because the ground truth of how they've decided what things are has not been well established. And these are, mind you, in relatively simple questions about, does the face of me look like me? And they're not very good at getting dark skin and things like that, but they're getting better at it. We're not talking about legal judgments here. And legal judgments are hard, right? Reasonable lawyers can disagree about what the right course of action is. So to anticipate that a machine learning tool can pick up what should be the right course of action is an enormous demand that you're placing on the right course of action. And for those of you who I've spent more time than I care to on legal discovery in my time as a prosecutor and as a litigator, but there's a huge difference between a e-discovery software that purports to tell you what's a relevant document. That's actually, it can tell you, okay, this was a purely personal chat, or this was a discussion about a particular legal issue that you were interested in, versus a hot document, right? What's an important document? What will actually move the case forward? That's a much, much harder judgment to make. And we see that trying to automate those kinds of judgments are impossibly hard. I think actually it requires human judgment at the end of the day. And I think a lot of the legal services, if you flip back to what the services that people need, are services that actually do demand a lot of human judgment to help the consumer through it. And advising a legal strategy is then an even higher bar, right? So it's not just telling you, well, here's the right outcome, but then here's how you go about it. That's really very challenging for software to do. So the other part about software, it brings about some broader risks, right? So errors are inevitable. That's just the nature of how these softwares work. But who's going to be responsible for those errors? What's going to happen? How do the consumers know that they were in that minority category who was, for example, an error misidentified the legal issue for them? What are they going to go? Who are they going to turn to for redress? And part of that is how do they understand? How's that decision that the machine learning software makes for them? How's that explained to them? How do they make sense of it? And then, and Wendy referred to this, but there's a whole other area about how when you're doing machine learning at scale from data that we have about society, we're going to pick up and risk reinforcing biases that we already have. And we see that in the racial field, we see that in a variety of different areas, in gender. So you're seeing how actually the machine learning can amplify bias. And that is something to really be concerned about. And I think the other risk, which is, the tech solutions in this space can distract us from more consequential interventions, right? So whether we spend a lot of time and energy on trying to find the tech solution when in fact maybe there's another kind of solution that's much more effective for what needs to be done. But these problems about how hard it is to use machine learning for judgment. My colleague at Princeton did this incredible study of trying to predict the outcomes for individuals who were picked up in a cohort of young people as to what their life outcomes were. He ran this massive, it was a competition to apply the latest and greatest machine learning tools to try and predict the outcomes for these kids. And lo and behold, none of the machine learning tools worked all that well because it's very, very difficult to predict human behavior. It's very difficult to adapt to the human judgment that's required. And so I would, from my perspective, and I know I'm here just to share my perspective, is that there's some fundamentally dubious applications of machine learning, and there's some that are possible, but they require a lot of oversight. And so, from my perspective, the possible places are where it's helping people fill common forms, whether it's flagging certain errors in applications, identifying ways in which you might deviate from a standard pattern. That seems like areas where it is possible to think of creative use of automated technology, but it's very different in helping people with negotiations, and helping people with representations, and helping people in the kind of challenges that they're really coming, I think, to lawyers for, and are afraid to come to lawyers, as you've identified in your report, but that they're looking for places where they can navigate their child custody disputes. They can look places where they can navigate their healthcare disputes. And so I think the key takeaways I would have for your group would be to say, on the dark patterns, is to say, what's the provider's business model? How do they make money? Is it sustainable, or does it depend in some ways on exploiting the users who use it? And then in terms of the second one, the AI hubris, is just to ask the simple question, how do we know that insert technology, whatever it is, actually works, right? What's the basis for that? How has that been verified? How do we assure that it's not something that is going to take advantage and distract us from more consequential interventions? So let me stop there, and apologies for running through my time, but I'm happy to stick around and take questions for the time that you would like me to answer.
Well, I appreciate that very much. What I'd like to do, Patricia has the first question, and then I'm going to let anybody who has already asked a question state their question. And then when we have a whole bunch of questions, we'll let you respond to as much of all of them as you can, a sort of free for all. But Patricia, before we get to the free for all, why don't you ask a question and we'll give him an opportunity to answer it.
Okay, thank you. And thank you for presenting this. It was really helpful. I wrote down my question just to remember. And I was thinking of this presentation in the context of disrupting consent and misuse of sensitive data. Wendy, I don't know how to pronounce your last name. I apologize for that. Did bring up a good point about having some clients that have safe, like medical information. So I understand that there's personal injury cases and things that have health data. But my question for you is that I know that FDA has provided guidance on AI use in healthcare system software. Do we have a counterpart for that, or has anything been drafted for AI guidance in legal software? And how would that come into play when you have when you're trying to bridge the gap between using this new technology that we're developing, where there would be some legal software guidance with AI technology, and then you're also having to comply with maybe some standards that were captured from using health data or sensitive data. So it's like a multi-part question, and I know it's very vague, but I'm trying to figure out, this AI technology is complex, and we're still learning about the pitfalls and the advantages, but is there any guidance in place, and how do we bridge the gap between the AI guidance for healthcare, for example, with the legal software AI guidance? And who would publish that AI guidance for the legal software?
Yeah, great question. I think to take a step back, I think the FDA if you think about it, the FDA is really starting on its journey to decide what AI can do. And part of that is that they're developing their tools, but you're also seeing that the AI itself has been changing. And so they've been appropriately cautious about using AI in the medical setting, right? So identifying whether you have certain issues is something that requires FDA approval to use. If you're going to scan an image to tell you if you have cancer, obviously you want to have a tool that's been vetted and that actually does what it purports to do. That is not something that exists in the legal market. Maybe there's I think a reason to think about before you approve of a tool to ensure that it actually does what it claims to do, and that you can actually go about trying to assess that. How that interfaces then with the use of the healthcare data, that's a more complex question about how that interfaces with the FDA system. And again, that's something I think that'll be an area of evolving guidances. But it's not by any means something that is easy to detect.
Thank you for that. I see two more hands raised from folks who have had a chance to ask a question previously. So I'm going to go for this panel question format. Marta and Wendy, if you would both state your questions, and then we'll let Mr. Kshirsagar, I apologize for mispronouncing.
No, that's perfect. Yep.
Provide any final thoughts in response to those questions or otherwise, because we have run through our time, but that's because he has so much interesting to say.
My apologies. I did not lower my hand. I do not have a question.
Okay.
Thank you.
And maybe Wendy, was it the same situation?
Yes, I really appreciate him addressing those issues that I raised about, the waiver of arbitration rights, ethical AI, and access to data. I think those are important issues, and I'm glad that he started with addressing those. Thank you.
Super. Then I can only add my thanks to those of the people who have asked questions and say that this was tremendously useful. I hope you don't mind if we might come back to you with follow-on questions through Tom Green, but we really appreciate the wisdom you shared with all of us today.
No, it's absolutely my pleasure, and I'm very happy to remain in touch. And Tom knows where to get me. But yes, and just one quick parting thought, and I will share this link later with Tom. Is that I see that in the chat that there's some various sort of examples of what AI-based systems are doing, and I would be very, very cautious about relying on some of the hype that surrounds what DeepMind does, or what Google does, or what Facebook does. They struggle with the very basics on this, and we have. I'll send a link to some of these challenges with, how you can use AI when there's a repeated pattern of data versus where there's a much more complex set of things is a very different application. And so I would be very, very cautious as you enter into this field. But again, happy to talk about this more and happy to share information.
Thank you for that caution, and I will ask, and we'll say goodbye, and I will ask our State Bar staff to send us a copy of the links that have been in the chat along with the link that Mr. Kshirsagar is going to be sending us.
Great.
And with that, we will move on to, oh no, I'm sorry, I promised us a brief lunch break because we didn't really get one yet. So let's take a half-hour lunch break. Let's come back at 34 minutes. Let's come back at 1:45 from our lunch break. And when we come back from our lunch break, we will resume with briefly with the SAGE committee efforts, but rather than letting them go through everything they had on the agenda, we will move pretty quickly on to next agenda items. So see everybody at 1:45.
Thank you.
Welcome back, everybody. Welcome back, everybody. That was a really exciting, if sobering presentation. We're going to step back briefly to the discussion we were having under Mary's leadership on SAGE topics before we advance the rest of the agenda. So Mary?
Okay, thank you, Justice Tucker. And just to bring everybody up to speed, obviously we had a good discussion so far. We've got some proposed changes. In a conversation offline during lunch, we agreed that we would, SAGE would take a look at these proposed changes, and we will have a hopefully briefer discussion of these sort of reformulated proposals at the September meeting with the input taken into account. So with that, we're just going to talk about item 6 on this first set of proposals. We will defer discussion of the second SAGE set of proposals on the risk regulation, the risk-based approach to regulation to September, and then we'll move right into scope. So with that, let's turn to item number 6, which this is an attempt to define some term for the sandbox. And we went, and that is so that to encourage participants to actually apply and want to be a part of this and not have a fear that the sandbox is going to, end within, a very short period of time before the project would have a time to get established, et cetera. So we propose that it be established for an initial period of 7 years, and that if the legislature does not improve continuation after 7 years, then the Supreme Court should make a provision for active sandbox participants that seek to continue to provide. Somehow we just lost, or I just lost the.
I think we all lost it.
Okay, thanks.
Come back.
Could we go back to the thanks? So the reason we chose 7 years, it wasn't arbitrary, even though it may look somewhat arbitrary. That's the length of time that the Utah sandbox recently, after consideration, recently expanded to. And we think that is enough of a time to allow, a kind of substantive participation in a program like this with meaningful participation from, participants et cetera, and then data collection and all of the things that the Sandbox is intended to do, which is to provide a kind of laboratory for, determining to what extent we can provide safe and effective legal services, within a different regulatory structure. So with that, I guess I would just open up discussion. I don't think anybody here of the committee played a particular role in determining this time period, so I won't invite particular comment from committee members, but please feel free to weigh in as part of this discussion. Justice Tucker?
Just as a point of clarification, I want to find out whether you intend the language towards the end of this item to be the way I read it. We talk about how if the legislature chooses not to continue, that the Supreme Court should make provision for active Sandbox participants that wish to continue providing their authorized services to do so under such terms and conditions as the court deems appropriate. I assume that the court could say, yeah, we deem it appropriate that this particular entrant not be allowed to continue providing services. And so what you mean is not just under such terms and conditions as the court deems appropriate, but to the extent that and under such terms and conditions.
I think that's a fair amendment.
That was exactly the same question I was going to ask, Justice Tucker.
Mm-hmm.
Oh, wow. Well, then may I propose it as a friendly amendment? It would be after the phrase "to do so," we would just add the words "to the extent and." Yes, that's right.
Great.
Micah.
Thanks. I have a question about the language we just amended. If we're asking the legislature to essentially excuse Sandbox participants from the requirements of code sections, how is it the Supreme Court would have the authority to say, we're going to also excuse you for this other extension of time after the 7 years? I'm confused about how this would work in reality.
Well, unless Mary wants to answer that, I can say how I understand it to work.
Sure, go ahead, Justice Tucker.
Which is that the legislature, in authorizing the Sandbox and in authorizing the Sandbox to allow entrants to waive compliance with specific statutes, would be authorizing that they could continue operations without having to comply with those specific standards once they're authorized to do so by the Sandbox entity, even if after 7 years the Sandbox entity gets wound down. Unless the legislature, of course, wants to pass a statute saying, oh, and by the way, it's going to be different. But what the proposal is, I think, is consistent with what the legislature would be authorizing at the front end, if that makes sense.
It does. I mean, what I've seen sunset provisions to do, though, is to completely sunset whatever the statutory change or the waiver is. So this is kind of a new animal that is saying essentially that there is a sunset built in, and the legislature may agree to that, and then there would be a request to extend the period of time. But whether or not the legislature extends that period of time, the sunset doesn't apply if the Supreme Court comes in and says the sunset doesn't apply. I've never seen that. So I don't know that that's how it works. So I'm wondering, has there been any legal research into this, or what kind of authority the Supreme Court has with given a sunset provision built into the initial report and ask?
I don't know the answer to that, Micah. It's a good question. I don't believe this was addressed in Brady's research, and I think we would probably have to do that. Oh, Brady.
I just want to make sure I'm understanding the question, because we're saying sunset a lot, but what it's saying is that the program will end. It won't accept new applicants, but this is, the proposal is to say, hey, legislature, you're recognizing that the existing participants from those 7 years will get to continue on, even if we're not going to continue the program for newcomers.
Yeah, right. So I've never seen legislation work like that. So I'm wondering if there are examples, because if there is a period of time built in, that is in essence a sunset provision being built into the legislation. So for example, we just saw it with all the extensions of time because of COVID and the SOLs being pushed out and the 5-year statute issues being taken into consideration with new legislation. But they all had sunset periods, meaning a date upon which that extension of time, that period of time would end without any further action. So no new legislation necessary, no new signature by the governor. It was built in. So if we're asking the legislature to establish this regulator for a period of time, that means when that period of time ends, the sandbox ends unless there is new legislation.
That's not what this recommendation does. Like you said, it's different.
No, I understand that it's different. I'm wondering what the legal authority is for that. What the statutory, is there a history of statutory construction? What authority does the Supreme Court have to step in and override a sunset provision? If what you're asking the legislature to do is say it's established for 7 years, but once you're in, and it can keep going on, even though the legislature is not funding it or authorizing it or providing waivers, that's a different legislative, statutory, that's different statutory language.
Yeah, that's how I understand the recommendation.
Right, and okay, so I mean, I guess I'm belaboring it, but through my experience working in Congress and the legislature here in California, I've never seen anything like that. So my question was, what is the basis for this suggestion? Are there examples of where this has happened before? Is there case law interpreting it? Is there some inherent power the Supreme Court has that I don't know about?
So I don't think we can answer that question right now. So it's a good question. And since we're pushing this whole thing to September, why don't we address it at that time?
Okay, great.
Does that work? Okay, thank you.
Thank you.
Marta?
Just to kind of echo what Micah is saying, I think the problem that I'm having with this section is if the sandbox regulator sunsets in 7 years, but yet there are still entities that are still existing and allowed to operate, who is going to be monitoring, policing, disciplining, evaluating the services that are being provided when the regulator is no longer around? So that I think there's an inherent conflict with respect to this proposed language in section 6. And so I think there's a problem. I mean, I think if we're going to sunset it, we can sunset it and it just ends, or there's going to be different legislation that is going to be introduced and passed or not passed. It's going to continue the sandbox program. But I'm not quite sure how it can, the regulator can sunset, but yet entities can continue to exist without any type of structure in place to monitor those entities that are in existence.
Yeah, Neil?
Sorry, so to piece together everybody else's comments. So the way I read this, and I agree the word regulator, Marta, tends to throw things off, but the way I read this was that if the legislature does not approve after 7 years a renewal of the sandbox, then the folks that, as per the Supreme Court's authority to regulate the practice of law, can allow certain participants to continue onwards. And that's why also you've got the phrase authorized service. So what I'm trying to say is the way I read this was a difference between the sandbox ending and the rules changing. I read this as saying that if after 7 years, the legislature says that the sandbox experiment now ends, that then whatever changes to the rules exist can allow these sandbox participants to continue to function as deemed fit by the Supreme Court. That's the way I was reading it. But I agree, Marta, the word regulator kind of throws things into a different.
And thank you, I appreciate those comments, but I think it still begs the question as to if those entities are allowed to exist, who and how are those entities going to be monitored, disciplined? Transparency is going to be established, making sure that the legal services that are being rendered are in the best interest of the folks that are using them, et cetera. That's my problem. If the sandbox isn't there, then how are these entities going to be continued? Who's going to be looking at them? Who's going to be watching them? Where's the watchdog entity making sure they're doing what they're supposed to be doing and not taking advantage of the people they're trying to serve? That's all.
Right.
And I would say that, and I think that John was primarily involved in drafting this piece, and I don't think that his intention here is that the entities would not, the participants would not be regulated at that point. But I don't think the specific form of regulation is spelled out. But let's get more comments, and we'll take all this into account. Crispin?
Thanks very much. I just want to take us back to the policy intention here, and that should really drive what the wording says. You know, for this trial to work, whatever the scope of it, we need to attract applicants, and we need to attract a broad range of applicants. And having a short period of time or a cliff edge at the end of any period of time will be a significant barrier to people coming into the sandbox. Big businesses won't make the investment in people, technology, compliance, ethical construction of the business if there is a really serious possibility that even if they behave perfectly well, extend services, show innovation, that they could just have to close their business down after a fixed period of time. So our intention here is to make sure we're attracting people in and give them some certainty. And we should hold on to that if they come in and behave well, they'll be allowed to stay in the legal market, even if we decide, or the powers that be decide in 7 years' time not to take new entrants into the sandbox. So I think we should stop talking about sunset, because nobody's sunsetting anything. What we're saying is that we will take new entrants into the sandbox for a period of 7 years, and it will be reviewed after that as to whether or not it will continue. But for anybody that comes in and behaves ethically, and as long as they behave ethically, they will be able to carry on past that 7 years. So I think that tackles some of the sunset issues, but I also think that the chair's addition of to the extent and that's been added in, we should just be clear what we mean by that. I wouldn't want that to be just kicking the decision down the line 7 years and say, well, the Supreme Court can just decide whether it wants to close this down, including for people that have behaved ethically. You know, isn't our recommendation that the Supreme Court, of course, has got discretion on individual cases, but our recommendation is that as long as people are behaving ethically, those that have entered can continue subject to being appropriately regulated into the future. So to the extent isn't an absolute freedom for the Supreme Court. We're recommending something a little bit less than that, I think.
Okay, Eric?
Just wanted to pick up on something that Crispin said. I guess when I thought of this, I hadn't thought of this as clearly until we started having this discussion, but it's almost as if the regulatory function, and again, I like the idea of not using the word sunset, and I'm not going to violate that, but the regulatory function, I would presume, does not sunset, right? As long as there are entities that are continuing on that were under the sandbox, there would be some provision made to sort of continue regulating them in some way, whatever that is. The part that sunsets is that if this is not renewed in 7 years, then the sandbox would not take new entrants and review them. And so I think what we were thinking on the committee was essentially that the part of this that has to be renewed, because this is designed to be a pilot program, is that the legislature would not have to approve, in perpetuity, this way of entering the California legal market. But that once we had let people in, we gave them the certainty that this would sort of continue and the regulation would continue to be through the sandbox. Now, I don't know statutorily how you construct that, but I think it's important to separate those two functions because the court would need a way to continue to regulate those firms that had entered if we decide to not continue as a state to allow new sort of entrants in through this pathway.
Yeah, thanks. Tom, then Kevin, then Wendy.
Yeah, not to be cranky, but I think this is a massive change up in the mission. Firstly, 7 years I think is way too long. It should be more in the 2-ish to 4-ish year time frame. The idea here was to conduct an experiment. Will these things work? And then if they do work, then we'll re-up. So sunsetting, we can't, and I think we all have every hope that these guys will work, at least under most of them, and that the legislature and the Supreme Court could then go forward with an extension. But there needs to be an end point. And the notion that once you're in, you're forever, I mean, that is no part of what we've been asked to construct here. So I think I just completely reject what Crispin just suggested. We're not creating an equity. If you're more or less okay during the sandbox period, you're in the California market for the next 5 generations. That is not what we had in mind here. I mean, I think what we want to do is to allow people in. We're running an experiment. We're going to monitor them carefully, and then we decide to go forward. I think this notion that there should be an automatic extension is really very difficult to square with what we've been asked to do. There's another set of technical issues, which is lawyers are regulated in at least 3 dimensions. There are constitutional provisions, there are statutory provisions, and there are ethical provisions. So in order for the Supreme Court to act in the way that this suggests, they would have to be authorized by the California legislature to do so. I mean, I suppose that's technically possible, but that would be something we would need to ask the legislature to do and broadly delegate authorities to the Supreme Court of California. So I really think we need to rethink this, both in terms of the time period for the experimentation and then this notion that somehow an equity is created so you're in California forever. I just think that's going to be very difficult to sell to key constituencies, frankly, including mine.
Okay, Kevin.
Okay, I have some of the same concerns that have already been expressed about this, but I think, remember what we're doing here. We are asking a question. I'm jumping ahead to the application as to why are you applying to the sandbox? You're applying to the sandbox because otherwise you're prohibited by rules or statutes from providing legal services under your model. And the sandbox will suspend for that particular applicant certain of the rules and certain of the statutes for that person, so long as they abide by the regulations of the sandbox. What happens when the sandbox ends? They're now allowed to go forward. If the rules and statutes aren't changed, that means that they're going to be treated unequally from anyone who just happened to not jump on their horse at the beginning of this experiment to try and find out whether they're going to be able to deliver legal services according to the outlines that we have provided the people who are entrants to the sandbox. So I see this as being a real problem that we need to discuss further, because in essence, you're saying we could end up suspending rules and statutes for this particular applicant going forward. Where's the competition going to come from? We're always going to be concerned about cost of legal services, and we're going to want to have perhaps new innovation, new people coming in. I concede that one of the concepts of the sandbox was an experiment and maybe changing the laws, and we might change the laws, but there's nothing in here suggesting that the laws will actually be changed because we can't know. But I do see a real problem if the sandbox is ended and certain people proceed under one set of laws, even though the laws haven't been changed.
Okay,
Those are my
thanks.
comments.
Wendy?
Thank you. I have similar concerns. I think that raises anti-competitive advantage as well as antitrust issues. If you have locked in entities that are given basically unregulated, and if they would be regulated, if it's not by the sandbox, then very likely it would be by the state bar with its existing structure, which begs the question, why do we need a separate entity in the first place? So in terms of the time period, I agree that it's excessively long to do an experiment as opposed to locking in some competitive advantage for business, which is not the mission of what we're here to do. It's to provide legal access to legal services for underserved communities. So I have all of those concerns about allowing entities to proceed in an unregulated manner and also with an anti-competitive advantage.
Okay, thanks. And I'm just trying to run through everyone who has their hands up. I just want to note that, we haven't actually voted on our mission statement. That's come up a number of times today. And I know we've had a lot of discussion about the mission and we'll continue to do so, but I don't think any of us should misrepresent that we have a set in stone mission statement. So let's go on to Becky.
Thank you. I just want to speak to a couple of things about the issue of duration. So in order for the experiment to work, you have to get enough data to understand what happened. And one of the most important reasons that Utah extended from 2 years to 7 was that it was incredibly clear that 2 years was not going to be enough time to understand not enough time to see if something bad happens to observe harm, but definitely not enough time to see if there are impacts on access to justice, because this project would try to do two things: to increase access to justice while maintaining consumer protection. Now, if these services are actually new, that means consumers don't know about them right now, and they don't know about their appropriateness for their problems right now. So consumers have to discover them, recognize that they're relevant, and for things that are new, that takes a certain amount of time. And so 2 years just isn't enough for that. I want to echo Crispin's point that if you're asking people to do something that requires an investment, even just of time or organizational restructuring, they need to feel like they have enough time to try that investment out, knowing that many of those will fail, right? Like any startup, but they need a chance for it to be physically possible or fiscally possible to make a return on whatever investment they've made. And it's pretty clear that 2 years in many instances is not long enough for that. I just want to raise one more issue, which is that at least in Utah, we have rules about exit. So if you attain a certain level of performance for a certain period of time, then you get to leave the sandbox and you're an authorized entity to continue doing your thing. And your reporting requirements are scaled way back. So it's not that no one's watching you, but the way you're being watched and the way you're being monitored is different because you've shown you can do your thing for a fixed period of time at an agreed upon level. And so those who are raising issues about how to do this through statute, how to do it through resolution, I defer to the experts on that. But I think substantively, one thing you want to think about is how long does this experiment have to run to achieve its goals of being an experiment and producing the data you need to answer the question? How long does it need to run to get enough people to be willing to participate in your experiment so you can get the data to answer the question? And then realistically, if these things are not harmful, you would want to let them out into the world. You'd want to let them out of the box. And so there will probably be some provisions for exit. And those would mean that even if the thing never sunsets, there would be entities out there doing stuff that the sandbox had decided was now okay, because by observation, we learned it was fine. And so that's going to happen anyways, under most ways that this might work. That's all.
Okay, thanks. Bridget?
Sorry, mouse is not cooperating. Becky just said everything I was going to say. So thank you.
Okay, thanks. Toby?
Yeah, I would agree with most of what Becky said. I had a few other points. The time duration, it's not just time for people to learn about it, but you start the project, you've got probably 6 months or more to get it up and to get the sandbox up and running, to get the application